Good morning. Our attorney informed me that we could actually start a couple of minutes early. So we'll start early. I guess I'll do this, and can we please start with a roll call of the commissioners?
Chair Benton.
Here.
Vice Chair Boygan.
Here.
Vice Chair Holton. Commissioner Egger.
Here.
Commissioner Hawkins.
Here.
Commissioner Jolly.
Here.
Commissioner McGowan.
Here.
Commissioner Oberter.
Here.
Commissioner Randall. Mr. Chair, I have 7 of 9.
Thank you very much. I believe we have a slight variation in our agenda for today.
We do. First up is a revisit of an enforcement matter that you heard yesterday morning. The docket number is 181000770. This is the Fortigen Resources waiver of Rule 707A. I believe staff and Fortigen's attorneys have reached an agreement. You have a red line of that in front of you. I also have a clean version if that would be preferable.
Commissioners, are we okay with the red line version that's been handed out to us?
Yes. Mr. Chair, could I?
Yes, Commissioner Boygan.
So the one concern that I have is I'm not completely clear whether next July, if the wells have not been returned to production and some well, if not all the wells have been returned to production and some of the wells are still inactive, whether the bond amount would have to be increased. Basically, whether 707 is reinstated, the bonding requirement of 707 is reinstated.
Yes, that's the intent. The modification is only through the pendency of the Rule 707 compliance plan. And if any wells aren't returned to production at that time, they'll be MIT'd and bonded under the rule as written.
I noticed the language in the order that says they will be and bonded, and I just wasn't totally clear if that meant the inactive bonding requirement would be applied, or if there was some other. I just wasn't sure if that was the intent, was that language referred to the inactive well bonding requirement.
Mr. Farron?
Yeah, so we just met in the hall and had a few slight tweaks to the version that's in front of you. One of them would address that issue. I can go over them quickly, or we could pull it up and fix it if that's easier. But the first would be that the written report be submitted 2 weeks prior to the January 28 date so that staff could look at it and decide whether to make time on the agenda. The second would be to clarify in the order section that 707 is modified from 2 million to $500,000 through July 1, 2019. So it's clear that 707 remains
Great.
in force after that date. And the last would be to strike some language from paragraph 2 of the order, or schedule for the prompt plugging and abandonment. There was just a little miscommunication about that, and it seems like Fortigen is willing to MIT their wells and bond up, so scheduling it for plugging wouldn't really satisfy us. So,
You repeat the change to number 2 again, please?
so there's in your red line version in the order, page 4, paragraph 2, just strike or schedule for the prompt plugging and abandonment.
Yeah, they're required to return to production or plug and abandon. Okay.
Or MIT.
All right.
Or MIT and bond up.
Or MIT.
Yep.
So essentially follows 707.
Yes.
Okay. Commissioners, are we prepared to move forward with this as written? Yes, Commissioner Egger.
I just have a question about the report. So you said that the report will be required 2 weeks prior to the hearing, and staff will determine if it needs to come to hearing. So what, I guess what actions can we take should that report not be to the level that we would expect it to be if we find out they haven't done anything?
I think at that point you could modify this order, assuming you enter this order today. And I the AG would have to tell you what you could do at that hearing, but
Okay.
I think if they have failed to comply, I think we will get that report 2 weeks prior and probably put it on your agenda because we would be frustrated as well.
Okay, thanks.
Commissioner Ager, do you need any clarification from our attorney, Mr. Davenport? Are you okay?
That's good enough.
All right. Okay. Any other discussion, commissioners? Yes, Commissioner McGowan.
I just want to say thank you for relooking at this and being willing to make some changes. And I realize that this is a crappy situation and you're making it a lot less crappy. I guess that's the best way I could say it. And I really appreciate you guys coming back and giving us some assurances that there's some good faith effort here, that we're not going to be left holding the bag again. And I really appreciate it.
Thank you for those comments.
Yeah, thank you very much. And Mr. Hayworth, we're sorry we took one more day of work away from you to be out there getting those wells back on. All right. Are we ready to entertain a motion then to enter the order as revised?
I would move that we enter the order as revised.
Is that
Approve the order.
the appropriate way to word that, Mr. Davenport, just to make sure?
Sure, I think we'd clarify as well that includes the discussion that was just had about additional modifications made to the red line that Mr. Farron and Ms. Ryan informed the commission about.
So the motion be made by Commissioner Hawkins to enter the order as revised, including the slight verbal changes that took place this morning that will be entered into the final order and when it is finalized and sent out. So the motion made by Commissioner Hawkins, is there a second?
Second.
Seconded by Commissioner Ager. Any further discussion? Are we ready to vote? All in favor, say aye. Aye. Opposed, same sign. Motion carries. Again, thank you so much for your patience. Great work and good luck.
Thanks, commissioners.
Thank you.
Okay. Ms. Prine, what's next?
Mr. Chair, next you have 2 brief presentations on URU reviews. The first one is from order number 54014, which is an SWN review, and that will be followed by Great Western, order number 535827.
Very well.
And thus ends my streak of being the last on your docket. Good morning. Michael Jewell, Burns, Figa, and Will, on behalf of Southwestern Energy and its wholly owned subsidiary, SWN Production LLC, affectionately known as SWN. The last time we were before you was about this time 2 years ago, 2016, up in Sterling, where Leanne Hicks of Southwestern gave her presentation and discussed the problems with drilling economically. We had just not quite entered the more recent uptick in prices. But at that time, we committed to you that we would terminate the remaining URUs that would not be developed under any circumstances that they can tell. As you may recall, there were 18 originally, one that was drilled with 1 well by its predecessor, Axia. So immediately after that October hearing, we filed for the remaining 12 to be terminated. You approved those, I believe, in the September hearings in, I'm sorry, that would have been November hearings. I forgot where though, my apologies. But all 17 were then terminated, leaving the one with the Bulldog well. So fast forward around August of last year, we met with Ms. Stancic, former Director Lepore, and Hearings Officer Durancy to discuss what the report would look like, because I think you would agree we had some bit of a stalemate that with the inability or the lack of desire by SWN to drill in this asset, there's very few things we could look at. But we did look at the possibility of reconfiguring the unit that has some rather obvious problems with fairness. If you already have X number of persons receiving benefits from the Bulldog well, to chop it down, if you will, to a 1280 would unfairly cut out some owners. So that was not deemed to be an appropriate mechanism. So the well is still producing pretty well. So until the day that it could be plugged and abandoned, or the day that Southwestern sees prices that are suitable for coming back into Colorado, they haven't been active other than maintaining their wells since this past time 2 years ago. And we believe the appropriate action now would be to file an application to relieve any further reporting or with any other insight from you commissioners. And at that time in 2017, we did not report to you. We did reach out to the 510 parties, but as you may recall, that was when some turnover began to happen, plus with our stalemate with staff and trying to consider what we could do. I think it just never made it on the docket. So apologies and any inconveniences to you for that. But remaining today that we have no intention in the foreseeable future of developing here in the Sandwash. I hope that would change. Southwestern does as well, but they are entertaining possibilities for the asset at the moment. So with that, if you have any questions for me, I'd be happy to answer.
Commissioners. Commissioner Boygan.
I'd like to hear from staff on this.
Sure, Commissioner. I think that's probably the right path forward. I mean, we have a commission order that requires annual reporting on the Bulldog unit. And as Mr. Jewell alluded to, there's been a big challenge in that these huge URUs were set aside, and we're holding a huge amount of acreage on the west slope, and releasing the units or dissolving the units made sense where there was no well drilled. And in the context in which we have this, which is there's a well that's been drilled and paid out, we're in a little bit more of a bind in terms of if we dissolve the unit, how do we account for that for mineral owners who've been paid, but their minerals haven't been drained, or vice versa. And so I think right now where we've landed is that leaving the unit in place allows a future operator to come in and drill out that unit or come forward and ask for a different size unit, and we can address the questions of payout at that point in time. So, I mean, if you want continuing updates on it, that's fine. We can certainly accommodate that request, but this is really kind of narrowed down to the question of whether the commission wants to continue to receive updates on a unit that has a single well drilled and an operator that doesn't intend. I mean, any operator can come in and file an APD to drill a well in the unit. There's no operatorship with URUs, I don't believe. So,
Can I ask a few follow-up questions?
Certainly, Commissioner Boygan, go ahead.
There are other operators besides Southwestern?
Forgive me, I'm looking at the spreadsheet that Ms. Stancic made. I believe Southwestern owns not even 50% of the working interest in this well.
How much?
Maybe not quite 50%. Look at my phone to confirm here, sorry. It looks like 52%.
And that's based on the pooled acreage within the URU?
Yes, sir. And that was the title run by Axia 2012 or so.
And how many acres again in this URU?
2,580 plus or minus.
Commissioner Boygan.
I just want to say I'm concerned about this. This is not an acceptable situation as far as I'm concerned. It's not consistent with the purpose of establishing URUs. We're basically allowing one well to continue to hold this large area with no drilling commitment and no plan for developing the area. And Southwestern gets to ride on the basis of, oh, we're already paying all the owners in the unit, so it wouldn't be fair to contract the unit. I think we need to explore alternatives because to me it's inconsistent with the purpose of establishing these units. And certainly on a going forward basis, if there's nothing we ultimately conclude we can do about this unit, we need to address the situation for future units. And then, you know, we can use the model of federal exploratory units where they establish participating areas. We can maybe come up with a concept for paying, I don't know, on a wellbore basis or contracting down to a wellbore basis. having that be a condition going in so that interest owners are effectively taking subject to that. I don't know, I'm just throwing stuff out right now, but to me, this is unacceptable. You're just letting Southwestern off the hook and letting them hold this large amount of acreage with one well with no, and Mr. Joel is candid in saying there's no present plan to do anything further with the unit. And there's apparently nothing we can do about it. I just don't accept that.
Commissioner, if I may respond.
Yes.
I think, or Chair, if I may respond, thank you. I think the challenge that I see is that, I understand your point about Southwestern, but as we look forward into what development may look like for this unit, it could take the shape of this 2,000 acres, or it could look like something else. And from my seat to step in and decide what that future development plan should look like feels a bit fraught. And so we could, as I see it, there are two options. One is to leave the URU in place, which allows any owner to come in and drill wells within it, or any owner to come in and respace it. Or we could talk about dissolving it and what that looks like and how we do that. And that just kind of opens it back up to somebody coming in and spacing it again when they come in. And so for me, it was kind of, it's a challenge to weigh what the best use of staff's resources are in that circumstance. Because I think on some level it will need to be respaced by a future operator. But we can, I'm happy to have the conversation about how to fairly retract the unit.
If I may.
You're the chair.
So that doesn't matter. I'm just another commissioner. Quick question on SWN's efforts to find someone else to potentially come in and take this over, do a partnership or something like that to help reduce the cost risk to SWN to go drill additional wells. Is there any current effort that you know of?
Not specifically, but in general, I was told yesterday by the landman who's now over this asset, they are entertaining a current offer.
They are.
They are. I don't know what phase, but that's what I know.
So having been here when we created this, this is one of the things that commission struggle with, is what to do in the event that something doesn't take place. And we talked about structuring it more like a federal unit. At the end of the day, we said, well, we'll get this efforts, because it seemed like there was a very sincere effort on behalf of Axia to go forward with this. The oil price environment changed significantly, which is something that was beyond their control. And I think what I hear out of that is that we may be limited to what we can do with respect to this URU without causing a lot of work for the staff, but lessons learned out of this, if another one comes forward, to tailor it more like federal exploratory units where there's a certain amount of drilling commitment, and there's a way that those units contract after a period of time if they don't continue to drill, and using that as a model for future URUs ourselves. I think there is certainly, because this is a high risk area, and the part of the reason it was created was to essentially provide the company that's spending the risk dollars to have the opportunity to develop it over a period of time on a reasonable basis, so that they wouldn't worry about somebody else coming in and grabbing the acreage. So I think wouldn't say that we're stuck, but I think the path forward is we let them continue to try to work to find a partner. I think it's one that maybe we come back and say, well, if you don't have anything within a year or 2 years, then we get together with the staff and say, what can we do on a path forward at that point, that we can come up with a way to unwind this thing, because it's not going to change. The issue is that we've got people that have been pooled in there, have been paid a certain amount of royalty, and it's going to be a struggle to unwind this no matter what we do.
Perhaps, I'm assuming a lot of the acreage up there is federal.
There is a lot of federal acreage, but I'm not aware of, at least of these 18 original URUs, any that had a substantial amount of acreage in them. If they were communitized and smaller acreage tracts, compared to the 4 square miles.
If it was a certain amount, they would have had to have been federal units.
Right.
If you go above a certain amount of acreage in there, then they would have had to have been put together as a federal exploratory unit.
If I could?
Certainly.
With one exception to letting us off the hook, Southwestern actually agrees with your comments altogether. We didn't create these units, as you recall, and we didn't drill this one Bulldog well. And as production began under Southwestern, you saw that we started creating spacing units that are, I guess, calling it a traditional Wattenberg size, 1280s, some 1100s, some 800s even, which appeared to be better for that grouping. So we agree, it was an unfortunate sort of prototypical start. These were the first URUs, to my knowledge, in the state, and moving forward, they have done better in other areas. And certainly, if they were to be proposed again in the sand wash, there would be more protections. As we discussed 3 years ago in our report, indeed, I agree, these look and have a feel more like a federal unit than a glorified DSU, if you'll pardon the term.
I know. Mr. Davenport, could you share with a little bit of guidance for us on what we can do here today?
Happy to. Thank you, Mr. Chair. So if the commission is if the commission is interested in just allowing this to move forward as it has and not making any change to the order, there's nothing to be done here. You don't need to move. You don't need to do anything. In the past, any changes to the timing of reports or relieving the operator of making a report has been handled based on a motion, and then the operator files a variance with the director to request a variance from that requirement of the order. If you would like to do anything more substantial to this order, retract it, vacate it, do anything else, it does need to be noticed and set for hearing. So your decision is, you are not today deciding whether or not to vacate or contract this unit. You're deciding essentially whether or not to set that over for hearing in the future to make that decision.
Mr. Chair?
Yes, Commissioner Hawkins.
I'm just wondering if it would be beneficial to have staff and the AG department give us some advice, say at the next hearing, on how we could contract similar to a federal unit down to something that would be a wellbore spacing unit. Because I think even if we don't do it on this URU, any future action or any future URU, we probably are going to want to have some kind of control on how we shrink it back to what's actually producing. And I think it would be beneficial just having some guidance from the AG's office and the staff on how we would go about doing that.
Sort of options and consequences.
Yeah.
Is that something that would be possible, Director Murphy? All right.
Yes.
If I might, Mr. Chair, I would
Yes,
just
Commissioner Boyd.
supplement what Commissioner Hawkins suggested. To me, the concept, it's a larger question about the purpose and structure of these unconventional units. I don't know how common they are. I'm not sure we use them a lot or approve them a lot. So there's a question of, how much staff time and resources ought to be taken up with this. This situation is unfortunate. It points out to me that we really don't have the structure in place. I mean, federal units have an elaborate regulatory structure, history, agreements that are in widespread and long time use. Everybody knows how they work. And here we don't have anything like that. We just have kind of an ad hoc, we'll approve a larger unit and you can just go do what you want and whatever you do is okay, basically. Mm-hmm. And maybe for our purposes, that's okay because we don't approve them very much. We don't encounter them very much. It's just not an exploratory kind of I don't know. I guess I would suggest that if we're going to approve or consider these kinds of units going forward, we need to rethink our approach to them.
Commissioner, I agree. And I think that staff has taken a much harder look at URUs or units that are disproportionately sized from what else is going on in the area because of what we've seen happen in this URU context on the West Slope in particular. We do have a couple of URUs on the Front Range that seem to be moving forward productively, but it's an interesting juxtaposition of issues when we consider the CDP yesterday. One of the things that was really paramount in my mind when looking at the CDP was that we had drilling and spacing units that were of conventional size. as compared to the rest of what's being drilled out, so that if we do get into this situation, we're at least looking at kind of a common drilling plan that could be transportable to another operator. So I think staff has learned a fair amount from the URU conversation, and it's been that I can think of one, I think URU that's been approved in the last 4 years for many of the reasons that we're talking about today is how do you guarantee activity?
Yeah, the point, I guess, is to encourage exploration and give operators adequate time and opportunity. And we want to do that, I assume, in appropriate circumstances. Just have to figure out how to do that in a way that's fair to everybody.
Yep.
And actually does encourage exploration and provides opportunity to other parties to come in if the designated operator is not. So it's just, again, I'm not sure it's worth putting a lot of staff time into if we're not going to be doing a lot of these. But I guess I would discourage using them until we figure out what they ought to look like.
Right. Yeah. I have to say that you're going over a lot of the same ground we went to when we first created these.
Okay, well,
Yeah, and
I wasn't here.
it's something that we struggled with at that time as well. And these were the first ones. And it was essentially to provide the operator the opportunity to do some exploration without the possibility of someone else coming in, although it did provide, as Mr. Jewell said, that there is an opportunity for other operators to come in here and file APDs and drill wells. So it's not as if this is frozen 2,000 or 2,500 acres. It's not frozen from somebody else coming in. And if they're talking to somebody now, I think notionally for me, it's best that we continue this on. Should we let them off the hook for reporting? I'm not so certain about that. It'd be nice to at least have some kind of a brief update on what's going on if they do find a partner or something that happens there. So that's where I am on this. And I think formally, if you want to change the reporting, you have to file an application. Is that correct?
Mr. Chair, may I?
Yes.
Thank you. So in the past, what this commission has done is if it's decided to grant a request to forego future reporting, there's been a motion for the commission to approve that request. And then what the operator does is file a variance request with the director just to formally follow our process and get approval to do that. You can certainly follow that here. Somebody on this commission will still need to make a motion to do that. If nobody's interested in that, then that no one needs to make a motion at all. We can simply say thank you to Mr. Jewell for his presentation, and that will conclude this report.
I concur. Would also add, minor point, but you could file an application to amend the order and just delete the reporting paragraph. But that seems to be a very reasonable route as well, Mr. Davenport.
Yes.
Director
Murphy.
Thank you. The one piece that I would bring up is that in the Bulldog unit in particular, we have a very active mineral owner, and that I don't believe. Are you here for Rollins too? Or
due to some family problems and health issues, they could not be here today.
Okay.
I anticipate the Rollins family is listening on the telephone today and wanted to hear.
Okay. Great. I just wanted to point out that we have a very active mineral owner council for that mineral owner. Cindy Bargell is here, probably for a different client, but a convenient circumstance at a minimum. So I think, and Mr. Rollins came and spoke to this commission in the July hearing or maybe the June hearing. So I would encourage you to think about that as we consider a path forward too, because I think that person would like to be heard.
Commissioners, any suggestions? We continue on. I guess guidance here. If we say thank you very much, then they're essentially going to need to come back and report to us again, correct? In a year. Okay. Director Murphy, you had some thoughts?
I mean, I think if staff came in December or January to give an update about what our options are, maybe the commission would be willing to delay making a decision about how to proceed with the annual reporting until that point in time would be one suggestion, and hopefully the Rollins could be present at that point as well for a discussion, if not a formal adjudicatory hearing.
I think that was, I guess we could put that in the form of a request that we'd like to have, not significant amount of staff time, but what our options are with respect to the potential consequences of things that you can or cannot do. I guess where I'd like to leave it is that then we make a decision about what the annual reporting stands as it is now, and then we make a decision about do we want to continue to do that or do something else. Or we leave it in place, if that's okay with the commissioners. Right.
Yeah, Mr. Chair,
Yes, Commissioner Williams.
I see no reason not to continue with reporting as an absolute bare minimum. I'd like to see some other steps taken. One thing that might be useful for me, since I wasn't here when this was approved, don't know much about the situation, is to see a list of who are the operators, who are the mineral owners. Is it an extensive list? How are people being paid? Whose interests are being affected here? Apparently there's a significant mineral owner who's actively involved who's just actively involved with the unit, overseeing it or concerned about it. And so I guess I'd just like to know more about it, but I see no reason to cut back on reporting. If anything, I'd like to see more frequent reporting.
Happy to make that happen.
Okay. If you want to change it, I think we have to, they would take the form of a motion that we would change the reporting scenario, or we could leave it as is, and then after you have a chance to see more and we look at the options in January, then we make a decision at that point.
Mr. Chair, thanks for clarifying. I'm not asking for any formal action right now. I think I'm just asking for a little bit more information and oversight, which I think we can handle on an informal basis for now. Appreciate Mr. Jewell's candor and his willingness to come before us and give us some updates, and I'd like to maybe consider continue along those lines on an informal basis while we figure out what's the best path forward. All right, my suggestion.
So what I heard is we're going to hear from staff in the January hearing about options. And at this point, we don't change anything with respect to the reporting requirements. I don't think that needs to take the form of a motion, but I'll ask our AG to make sure.
No, it does not.
All right, very well. Thank you.
If I may ask a clarifying question.
Certainly.
In the event, just hypothetical, there's a farm LT or maybe only a partial amount of the interest is conveyed to a new operator, I assume you'd want to hear from the operator actually drilling, correct? Because we don't have operatorship with this order.
Certainly.
Okay.
Yeah.
So if that's the case, I will be happy to inform you if and when any sort of deal is struck or the asset is sold or anything of that kind before the next reporting cycle would occur.
That would be something we would look forward to.
Yes, sir.
Thank you very much.
Thank you for your time.
All right.
Have a good morning.
Ms. Prine, Great Western is next.
Yes, Mr. Chair.
Well, we've certainly we've primed the pump for the next one, haven't we?
Hopefully this one will be a little bit quicker.
We do have a PowerPoint. Oh, Enrique's doing it. In the meantime, I'll just do a quick introduction. This is Kelsey Wazelinki from Jost Energy Law on behalf of Great Western Operating Company. With me are two representatives of Great Western. I'll let them introduce themselves and they will be giving you the update today.
Good morning. My name is Zach Warren and I am the Reservoir Engineering Manager with Great Western Operating Company. I'm here to provide our first annual update for the Pierce Niobrara Codell Unconventional Resources Unit. You can go to slide 2, or I can. This update has been delayed by a few months due to the very busy dockets that y'all have had over the course of the year, so I'll try to be brief. This is an informational update. No action is being requested on your part today. The Pierce URU was approved on the June 2017 docket by unanimous vote. It overlays the Pierce Lyons Federal Unit, a waterflood unit in the Lyons Sandstone that dates to the 1950s and is still in operation. We own over 99% working interest in the waterflood unit and have operated it since 2015. We have 88% working interest in the Pierce URU, which is 88% held by production from that deeper Lyons production. You can see a map of the area on slide 3. To date, we have drilled one well in the vicinity of the Pierce URU, the TNM DE 22039HC. I know you like these well names, located right here in section 22. That well was drilled and completed in 2017 as a part of a 640-acre drilling and spacing unit, so it's not a part of the URU. Although it successfully made oil, the results have not been as good as we had hoped. In contrast, Enerplus drilled the Maple 867-3625C about 4 miles away, shown here. The Maple well has substantially outperformed the TNM well to date, so we plan to mimic the Maple well in well design the next time we drill in the area by drilling a longer lateral in the north-south orientation. As such, we have submitted a permit for the TNM DE 33173HC, shown here, which we plan to drill in 2019 as our first URU well. That timing is constrained by the availability of gas takeaway in the area. Rimrock Energy Partners has proposed a gas plant immediately offsetting our TNM location, and we expect that gas plant to be available to take volumes in mid-2019. That gas plant is indicated, the location is indicated by a red circle right here. Waiting until that plant is complete will prevent unnecessary waste as we build the most efficient possible development plan for the Pierce URU. With that, I'd be happy to take any questions and look forward to providing another update this time next year.
Commissioners, any questions? Well, can't get away with it. At least got to ask one. The horizontal wells look like in 7 north, 66 west. Are you tracking the performance of those also?
Yes, and they've outperformed our TNM well, but have performed in line with the Enerplus well. You'll notice that a lot of those are oriented on an east-west direction.
I noticed that.
And most of what we've seen in the area in 6 north and 7 north is that east-west has outperformed north-south somewhat. However, one of the big wrench faults in the DJ Basin runs right on the southern edge of our Pierce unit, which is what set up the pop-ups for the Lyons oil fields to exist. And we now suspect there's a possibility that that stress orientation rotates on the north side of the fault.
And do you also have Black Hollow Field as well?
We do. We don't own as much of the Niobrara Codell interest there. A lot of those got severed somewhere along the way before they came to us. So we own the Lyons, but in a lot of those leases, we don't own the Niobrara Codell. So we operate both of the waterflood units. Black Hollow is a state unit. Pierce is a federal unit.
Thank you very much.
Thank you.
Ms. Prine.
Mr. Chair, next you have docket number 180900646. This is the pooling and hearing process rulemaking, deliberations, and decision. You began hearing about rulemaking on the 10th at a special, on the 3rd at a special hearing. I have provided to everyone electronically the red line rules. The red lines themselves have not changed since the last time we went through the rules. What has changed are the addition of some comments that you'll find along the right-hand margin. Those are comments that I pulled together based on issues that were still outstanding. It was my hope that that might help walk through the deliberation process.
Thank you. I was actually going to ask our attorney if he could give us a bit of guidance around the scope. Again, remind us of the scope of what we're here to do today. If that would, you would be able to do that, please.
Thank you, Mr. Chair. Excuse me. If the commission recalls, the record was closed at the conclusion of the October 3rd hearing, meaning that what's happening here today is solely commission deliberations. You are not receiving any new information from any of the parties or stakeholders. And as you deliberate, it's important to remember the scope of this rulemaking. The scope was laid out in the notice of rulemaking. I'll let you know what it says here. It says that in 2018, the Colorado General Assembly passed and Governor Hickenlooper signed Senate Bill 230, which modified 3460-116 CRS. That is the spacing and pooling statute in the act. The notice goes on to say some of the statutory changes made by this bill conflict with the current commission rules. Those conflicting rules require amending to ensure statutory compliance. Also, the commission is attempting to streamline its current application process to address the increasing backlog of applications it has pending. So that is the scope of this rulemaking as stated in the notice of rulemaking hearing. There's a legal principle called logical outgrowth. Any logical outgrowth from that notice is something that can be considered in this rulemaking as well. That would require an analysis of the specific issue that you're considering adding to the rulemaking in that case.
Clear as mud. So I guess where I was left with is that we have a red line document. We have some comments as we go along that we would look at the document and the comments and see what changes, if any, we want to make. I know Commissioner McGowan, you had some questions about some of the things that were raised on the some of the other items that were brought up, whether or not they're within the scope or out of the scope. And so my request is that when you've seen this red line document and the comments, is that going to capture what you wanted to make sure that we got out during the deliberations?
Thanks. So
Sort of vague, but
my, when Director Murphy asked for feedback about outstanding issues that we wanted to make sure were covered, based on the comments from, sorry, I have my notes from last meeting, so I think this was from COGA, the motion to strike.
yes,
And there were issues in there that they put 6 on the table and 1 and 6 were removed.
correct.
And I just wanted to make sure that we were on record to discuss why we were either going to include them in the red line or didn't include them in the red line, so that people would understand. I mean, people spend a substantial amount of time testifying as to what they would like to see added. And I think that while I'm sympathetic to some of the comments that were made during the hearing, I want to be clear why I in particular don't think they belong in the red line at this time. But I think they're important for discussion at some future date about how we conduct business here, or things that we consider as part of spacing, all those things. So, and then the other comment that I had, and I don't know if that was addressed either, was someone testified last time to their concern about the privacy of who owned, if I'm trying to remember, who owned mineral interest rights and whether or not they could have access to it. And someone said that at the federal level, that was not legal for us to be sharing them. And I asked for that to be clarified today also when I sent my comments in. So I don't know if someone looked into that.
And I know
Remember that conversation? And maybe
Yeah.
it's just not really that important, but it seems to me that someone was saying that we weren't allowed to share that information. But right now, if you went back into the records, you could find it anyway. So I just wanted that clarified.
it's in the comments. I think it's in the comments. I noticed, I think most of what you itemized in there in the motion to strike, I think we've got captured in the comments. So we can work through that, but perhaps it'd be useful to address this one first about the confidentiality.
Sure, Mr. Chair. Commissioner McGowan, we did look into any sort of statutory requirement to hold information confidential. The only requirements are based on CORA, and whether we have a right to withhold information based on a CORA request. Currently, we do ask for the information already. It's already being put on our website at a certain point. I think the issue was more about where in the process are we receiving that information? And does that give some advantage to another operator to come in and sort of swoop into the people who are noticed? We don't believe that the timing issue is substantial enough to cause us to have extra hearing process steps to receive something and hold it and not release it with everything else that we put on our website. But as Mr. Chair said, there is a comment in here where that rule comes up, and it would allow you to add some specific language around under what context we would share it and at what point in the process.
Does that mean we have to figure that out, or we're parking lot that for a different day?
That would be up to you. I can tell you that currently that information is publicly available. So that's kind of the bottom line of the confidentiality.
Thank you.
question.
When we get to that spot, we can talk about it some more.
Yep.
And decide we can
I'm good.
basically leave it as is or make some changes.
Yep.
All right.
Yeah, you, in the end, you answered my question.
That's
Thank you.
very clear. All right. With that said, if it pleases the commissioners, we can go forward and start with, looks like page 4, there's the first set of comments on the red line.
Hold them up on the,
Sorry, Commissioner?
hold them up on the screen too.
Sure.
Who did we make it last time?
3 or 4.
Mr. Chair,
Yes, Commissioner.
I just wonder if there's an extra paper copy of this.
I can make you one right now.
Great, thank you. Sorry.
Would anyone else like one while I'm printing?
Anyway, Mr. Boygan, would you like a paper copy also?
No, I'm good.
All
I
right,
was just going to email this.
all right.
Oh, great.
The review, people all mark up. I think the comments will show up.
Or I think, yeah, even if you, I think, is that a Word
It
document?
says simple, go up one more. Go to all, I think that gets you there.
There you go. So does it make sense we go through each comment as we go along and decide what we're going to do? The first one is adding mirroring language from 509A1A. And everyone, I'm assuming we can read that unless we want to have it read. And that would go in right where you've highlighted the word directly. Sorry.
Yeah, go ahead.
How would the revised version of that read if we inserted that language?
Mr. Chair, this was a party comment that came in on the 3rd to clarify, the language would be the same for who has a legally protected interest. It was a standalone comment, so I'm not quite sure how we would fit it in, but the idea was to make sure that the definitions of legally protected interest would be the same in both spots. So we can massage that language to make sure the definitions are the same if you would like.
It'll be something as simple as saying as defined in 509 lay 1 big A.
Sure.
Commissioners, what's your pleasure? Should we put that in there? Commissioner Ager.
I guess I would just ask the lawyers on the commission if this is just neater, if it makes everyone feel like it's just a housekeeping issue almost.
Commissioner Overturk.
I think there is some value in having the language be similar throughout the rules in order to avoid some confusion about who does or does not have a legally protected interest. So I don't think it hurts anything.
Yeah, I think legally protected interest is probably a important concept to a lot of people, and the clearer we have it, the better.
I agree. And so Commissioner Overturf, is that acceptable if we just say as defined in the other section, or would you prefer to have it actually spelled out here?
I think it would be fine to say have someone who, only persons who can demonstrate that they have a legally protected interest as defined by Rule 509A or something like that. I think that would be sufficient. But I just heard our
Yeah, I just heard our
grumble.
AG say something, so, or grumble. That was, yeah.
Just as a point of order, I don't think I was grumbling.
It was a harump.
Muttering, maybe.
Yeah.
I'm not sure. I'm just looking at the rule again, and I want to make sure that it actually, I mean, if we're going to treat this as a definition of something, that it really does actually define it. What 509A, 509A1 big A says is it's a description of affected interest, and it uses that language that you can see in the comment there, those who've demonstrated that they would be adversely and directly affected or aggrieved and have a legally interest that's entitled to legal protection under the Act. It's certainly not a definition in the definitions section. So I'd want to be clear about exactly how we refer to it.
You could say that they have a legally protected interest as set forth in 509A or something like that. I agree, it's not defined.
Yeah, so as defined, that's the engineer's choice of words, sorry. As set forth in. Mr. Boygan?
I'll hesitate to weigh into this, but I'll point out that the end of the rule says, and that their interest is entitled to legal protection under the Act. So there seems to be some redundancy here. I'm not sure what adding a legally protected interest accomplishes in addition to the language that's already there. So I don't know what our goal is in making this amendment in the first place to the rule, but clearly staff must have thought there's some additional category of parties who might get picked up, I guess. I don't know if you want to comment on that, Ms. Bryan.
Frankly, we are more than happy to mirror the same language that's in a separate rule to make sure it's consistent. We did not see a need to make that change. This change came from a party request. From our standpoint, we're happy to make the change if it makes people feel better that the language is mirrored in both places, but I don't feel like it's necessary. I think we have stated it the way staff would want it stated.
Including this addition of have a legally protected interest?
Well, the language that's there already includes that legal protection under the Act. So that part wouldn't change. There's,
Right.
so
Yeah, I'm just saying, I don't know why even the addition is there, but I'll just say from my perspective, I agree with Commissioner Overturf. I just as soon see us clean up inconsistencies throughout these definitions. So wherever you can do that, I think it'd be great. And by adding phrases, sometimes you don't clean it up, you add to the inconsistency. So I guess I'm just asking that you take a sweep through and try to make that call. But here, I don't have a strong feeling one way or the other. I just am not sure why we're even making the change in the first place.
Again, it was understanding it was a comment that was provided. So I think it was sort of this, what did you say? It's not, I can't say as defined. What was the Commissioner Overturf
as set forth.
as set forth? And I mean, I don't know if that adds any additional complication. It's fairly simple. Mr. Davenport.
Thank you, Mr. Chair. I think as an alternative, if this is something, if we want to just track the exact same language, there is a sentence, the first sentence in 509A1 big A, that can simply be copied over into this rule if we want to make it as consistent as possible, so that it says, what we're looking at right now says, for the purposes of seeking relief or a ruling from the commission on any matter, any other matter not described in 1 through 8 above, only persons who, and then we can move that language over, have demonstrated that they would be directly and adversely affected or aggrieved, et cetera, and track that language directly.
That makes it a little simpler.
Cool.
You okay with that?
Yeah.
Good.
All right.
Okay.
Let's do that.
Check.
Move on. I think we can all agree with in the red line that we have, there's a comment that says PJR1 with nothing there.
Yeah, that was.
So I think we can all agree with that one.
Screw up, sorry about that.
But the next one, PJ3, is adding language to clarify that changes made prior to notice being sent equals a corrected application and will not trigger new dates. So that's something related to, if it's just a corrected application, it doesn't trigger any dates? Is that the?
Yes, Mr. Chair. Again, this was a party request during the hearing on the 3rd, just to make sure that it's clear that before a notice has been sent, that an applicant has an opportunity to make changes and corrections to an application without it becoming an amended application, which starts a whole new process of dates.
And I looked at this one last night and it was struggling with how you would fit that wording in there. So perhaps one of our attorneys might have an idea. Or unless staff has come up with some possibilities.
If the commission thinks it's appropriate, this is a sentence or an explanation we could add to the statement of basis and purpose. If that's a helpful.
It's covered in the statement of basis and purpose?
It can be.
If it's not in as much detail as would be helpful, which means I can't exactly remember the language of the SBP right this second. It's an area where we could certainly explain that principle.
I'd be more than happy to see that happen as long as we address it in the statement of basis and purpose, if that's the pleasure of the rest of the commissioners.
Sure.
Okay. And the next one, Ms. Prine, can you explain that one, please?
This was a request by a party during the hearing on the 3rd that staff agreed to make the change. It was included in your red line, but I thought it might become sort of complicated to have changes thrown in. So the change was to add language and/or the relief requested requires a change. If you remember, this was part of the discussion on what constitutes a material change, what would trigger an amended application. One of the parties had requested that we clarify that, and this language was proposed during the hearing on the 3rd, and staff agreed with the change.
So it gets inserted right where the word currently requires.
Yes.
Okay. Commissioners?
I'm fine with it. That's good.
Mr. Williams?
I'll just say I'm fine adding the concept. As a general rule, I don't like and or. It either is or it isn't. Are they required to be joined or not? If either one of these on its own constitutes a material change, it should be an or. So I'm not sure what and or means. Other than that, I'm fine with the substance of it.
If we get rid of the word and, do you feel like it still means the same thing?
Yeah, well, it's either one of them if it's just or.
Okay. Are you okay with that, Commissioner Overturf? All right. So we'll strike the word and insert the wording that staff agreed to. The next one, is that sort of continuing on the same theme? Is that something that could also be put in the statement of basis and purpose?
So this is I will claim ownership over
Thank
this comment.
All right, Commissioner Overturf.
And not require Ms. Prine to speak on my behalf. So I'm not sure that this one could be addressed in the statement of basis and purpose, because I believe that would be inconsistent with the rule language as drafted. First, I'd like to state that I really appreciate that we're articulating this new standard that if you've undernoticed or if you're changing the relief that you're seeking, that you need to kind of start over from a procedural perspective. But I am concerned that over noticing and then deleting recipients of the original notice does not seem to me that it should rise to the level of requiring an amended application that kind of starts those clocks over again. My recollection from the hearing was that someone stated that the problem is that then people show up and they're like, well, I'm here because I got this letter, and they don't know that they've been unnoticed. And so I think we need to provide some clarity, and the clarity about what the remedy could certainly be provided in the statement of basis and purpose, that if you over notice people, then you need to send a letter to the people that received that notice in error and tell them like, whoa, stand down, never mind, you don't have to come. But the either adding or deleting recipients is I think problematic and would conflict with that principle. So we could simply say, we could have the parenthetical phrase simply say adding recipients, and I think that would solve the problem. And then include a statement in the statement of basis and purpose that says, if you over notice, you need to send them a letter and tell them, never mind. Man, I just blowed you all away.
No, so what you would say is that those who must be noticed, and then in the parenthetical, you just say adding recipients, or is otherwise determined by the secretary. That was what you would like to have in there?
Yes, and then clarifying that if you notice too many people, you still need to do something about that, so we don't have people showing up at hearings that aren't supposed to be there. But you don't have to start all over again.
And so then it would be a corrected application, not an amended application, if we deleted recipients.
I think the corrected application only happens if you make a change prior to when notice occurs.
Correct. I mean, if you
Notice will have occurred now.
if you notice people and then you had to amend it to delete recipients, then it does start the clock over again.
That's what I'm proposing to change.
Okay.
But it wouldn't start the clock.
So
The clock would change?
No, I don't want the clock to change.
Okay.
My concern is that under this language, the clock would change when you just over notice, which that doesn't seem like a good grounds to start the clock over again.
And yeah, so what I had heard you say then is that if we say just adding recipients, and then in the statement of basis and purpose, we would say we would put language in the statement of basis and purpose that we would send out notifications to recipients that were deleted, over noticed, but the clock would stay the same. Is that correct?
Or erroneously.
It becomes, it's not an amended application if you delete recipients. Is that a simpler way to state that?
My suggestion would be to change the clause and/or requires a change to those who must be noticed with the parenthetical, change it to requires notice to additional parties.
I like it.
Okay.
And just to be clear, I'm not thinking that we would send the letter that says, never mind, but that the operator would send that letter.
Okay. And so and then we'll put that wording in the statement of basis and purpose.
Yes.
Very well. Commissioners, are we happy with that?
Yes.
All right. On to the next page. I believe this is under 506 about adding language that allows the secretary to dismiss an application that has been repeatedly continued by an applicant or a protestant, or to force said matter to a hearing over objectives of applicant or protestant. Does anyone care to take ownership of that one?
Mr. Chair, this came up as a comment through the hearing on the 3rd. The issue for staff is that we have matters that are pending for long periods of time where the applicant or the protestant are requesting continuances over and over, but there's no settlement going on. There's just sort of a biding their time, holding their place in line. The issue is for staff is that holds up our process on those applications. And the other issue is that if you have a matter where they are in settlement talks and those talks are stalled over a long period of time, there's no mechanism for the hearing officer or the director to push the parties to go to a hearing in order to sort of get that moving along. So that's the issue in front of you.
And how would that look from a standpoint of wording? Would that be in this section 506? And
I put the comment in 506 because that's where the continuance sort of language is. To be honest with you, I'm not quite sure where that would fall. I just had it in my notes as an issue that came up.
Commissioner, I'm curious about thoughts on this one, Commissioners. Commissioner Hawkins.
Oh, I like the idea of giving the secretary the option to say, you know, this has been on the docket long enough and it's time to go to hearing. You guys haven't resolved it. Or just say, we're going to dismiss this totally unless you resolve it. I mean, that's one way to kind of clean up things that are sitting there for 6 hearings in a row.
Okay. Any other commissioners?
So
yes, Commissioner.
we want to be prescriptive that the situation where you can force a hearing is where one has just been continuing, or do we want to just simplify and say the commission may at any time direct the secretary to discontinue granting continuances or schedule something for a hearing? So either way, the secretary, if something is just churning, has the discretion to get it off our docket or schedule it for hearing. You know what I'm saying? So
Yeah.
because I'm guessing all sorts of situations could come up where you say, we've had enough. Some sort of decision has to happen.
It's certainly less prescriptive and it gives the secretary some leeway to come to us and say, we'd like to take this to hearing, or we'd like to discontinue granting the continuance. In fairly simple wording. Okay. I'm waiting on the director and secretary to tell me if what Commissioner McGowan said was acceptable.
Yes. From a staff perspective, there is nothing in the rule that gives us discretion to tell two parties, you have protested or you have continued this matter for 6 cycles, and we want you to either put up or shut up. We have no discretion to dismiss an application on our own accord based on any number of reasons. So I think staff's request would be that the director have some discretion to pull that trigger. And right now no one has that ability. So things just languish for months at a time. So the short answer is yes. Any language that would give us discretion to push to hearing or dismiss an application is what we're talking about.
Yes, Commissioner Overturf.
I think you absolutely have that discretion right now. And I think you have that authority legally. And so if putting language in the rules is going to make staff's work more comfortable and easy to resolve, then I think we should absolutely add this type of language.
Okay. So the one question I heard, the commission may at any time direct the secretary to discontinue granting continuances or bring the matter to hearing. The only question is it direct the secretary or the director? Mr. Davenport, sorry.
Thank you. I want to clarify, because what I heard Ms. Prine say is the way this sentence reads right now is the commission may at any time direct the secretary. And Mr. Chair, your addition would still require the commission to direct the secretary or potentially the director to take that action. However, what I heard Ms. Prine say is I believe staff would like the ability to do that without having to be directed by the commission to do it. It would require slightly different language.
If we just replace commission with director?
Do you want that authority, or do we just?
You would add maybe commission or director. May at any time.
Mr. Chair, may I make another suggestion?
Yes, you may, Mr. Davenport.
There is a sentence immediately prior that says the secretary or hearing officer will have the discretion to grant any motion for continuance. I think adding additional language there would accomplish it. To say the secretary or hearing officer will have the discretion to grant any motion for continuance, dismiss matters that have been continued repeatedly, or direct the parties to go to hearing. I'd be happy to hear suggestions though from the AG Larson or Ms. Prine or the director if they would like to see some other language. That was
adding an awful lot of words to a sentence. Sorry.
Mr. Chair, I don't want
Yes,
to interrupt
Commissioner
that, but I guess what I'm thinking is if the secretary has the discretion to continue a case, then that certainly includes the discretion to not continue it and force it onto the docket.
Right, that's what
Dismissing a case is maybe a little different. I don't know.
Effectively, you do that when you say we're not going to grant you any more continuances. You have, and then
Goes to
again,
hearing.
it's not prescriptive. It either is going to go to hearing or the parties may choose just to drop it.
Right, and
So
that's
we're
kind
not-
of what I think. It's just say, we're not going to give you any more continuance.
Yeah, so to discontinue granted continuances.
That doesn't
That's an
really
interesting way
require
to
much
look at
more
that.
language.
Go ahead. Director?
I think that is more in line with how, with the concept and continuing to let the parties engage how they feel is appropriate. Dismissal is not something to be taken lightly. And I would be hesitant, or stated differently, if this is the path we want to go down, I would want to explain in the SBP that we're talking about kind of indefinite cases that haven't resolved as compared to something that was filed one cycle ago. And for whatever reason, you know, I had a terribly bad tempered day and decided I was just going to dismiss everything. So,
Clear the docket.
I mean, I am cautious about how much authority you're giving me to wield in those instances. And so I would be more comfortable with grant or deny.
But if you go crazy and dismiss everything, then those operators have the opportunity to come to the commission and say, hey, commission, your director is going bananas, right?
Had a bad day.
That's probably fair.
Yeah. Either way, when I think about what Commissioner Hawkins brought up, the way that's worded is essentially, if you're not, by saying I'm going to dismiss everything, you accomplish the same task by saying I'm going to discontinue granting continuances, then the parties have the choice to either drop it or bring it to hearing. So more or less, even if the director goes crazy and says, I'm not granting any more continuances, then it's up to the operator to make a decision about what to do. And they can, de facto, they've come to hearing or drop the case. That makes sense? So notionally, if we leave it the way it is, you have your hammer.
Mr. Chair,
Yes, Commissioner Ager.
you just change the last sentence? Because the last sentence right now says that we have to direct the secretary.
Yeah. So you can say,
Are we giving the director?
say the commission or the director may at any time direct the secretary to discontinue granting continuances?
Yeah.
Yep.
I would think that's a great add. Yeah. Commissioners? Okay.
What was I'm sorry, I was reading and not listening. I should have been listening.
No, that's okay. The commission or the director may at any time direct the secretary to discontinue granting continuances.
Perfect.
Ms. Prime, does that feel like staff then would have the hammer that they needed? Essentially force the matter either to hearing or get dropped.
Yes, and we could clarify in the SBP as well to make sure that it's clear where we're trying to get to.
Good idea. All right, thank you.
I like that.
Not a very lawyerly approach to use fewer words instead of more.
That's why we have a few engineers on this commission.
And then a semicolon or an end dash.
Can't help that. The next page. And then perhaps after this page, we would take a break. The first one, how do you define all title work to be completed? And was that something that was a comment made?
That was a party request on the 3rd to clarify that title work had to be completed prior to notices being sent. I honestly cannot remember the context of that. No, generally, the title work is complete because they wouldn't know who to send a notice to otherwise. So, so from a staff perspective, I'm not quite sure how we, first of all, I'm not sure that that helps our internal process any, which was the goal. But also I'm not quite sure how we would enforce such a thing, or what would we, and I had the same questions about what does all title work mean?
And is this sort of start to step to a spot to where it's outside the scope of what we're supposed to be doing? And that, I guess that would be.
Well, that would be my concern. This did not come, as far as I know, none of the commissioners raised this issue. This was a party issue on the 3rd that came up.
Commissioner Overturf.
So it strikes me that if you have failed to complete your title work, that will result in inadequate or faulty notice. And so your application is going to be in distress because of your inadequate notice. So I'm not sure that I think this requirement is essentially subsumed in the notice requirements.
Very well. So we just move on. Okay.
So the next one is about mail. And I think this one is mine, if I'm remembering correctly.
That's a good one.
I don't have a strong opinion about it, but I remember this coming up multiple times during the hearing about what are the applicants supposed to do with the returned mail? And I don't know what the answer is, but it sounded like people wanted additional clarity about what the obligations were for returned mail. So help.
So currently what happens is the operator sends out the notice, but it's on our letterhead and our return envelope. So if you send a notice to me at the wrong address and it is returned, it comes back to this office, which means that the operator has no opportunity to cure that. And it's just a disconnect in the process. So it comes back here.
Can I ask why? Can we just-
Pre-Julie Prine, so.
My understanding of that evolution, Commissioner, is that for a long time, staff was sending notices out, kind of, which is, I think if you read the statute, what is kind of initially contemplated. And then as the volume of applications and the volume of notices has increased, slowly that burden has been shifted in parts to operators themselves. And so it's kind of a strange process where staff provides return envelope, provides envelopes.
Some actual envelopes?
We give them actual envelopes, yeah.
That's ridiculous. Is there anything that would need to change in terms of rule or guidance that would allow them to use their own envelopes and send them out under their own return address?
Well, that was our intention with the changes to number 1, that application and notice will be provided directly by the applicant using the applicant's return address, so that they have an opportunity to cure any returned mail that comes to them, so that they can ensure that they've provided proper notice.
So this providing that additional historical context about believe it or not, this is the way it's done now, and this is why we're changing it. So now this is providing that in the statement of basis and purpose, and perhaps it's in there and I missed it, but that may be helpful in terms of explaining how that's changed.
Okay.
Can we give people envelopes?
We're not there. I mean, we just migrated to iPads just a few years ago. So we used to get an awful lot of paper.
Yeah, but do they buy them from us? We just give them to them?
I don't believe anyone buys them from us.
So at this point then, Commissioner Overturf, you're okay with how it's being handled in the future? And
yes, and I think we've got a meeting of the minds about adding some historical context to the statement of basis and purpose, and I'm
okay. Very well. So that now if the mail gets returned, it goes back to the operator? Is that,
yes.
All right. And then the operator is going to have to be responsible for tracking down people?
Yes.
Cool. Okay. I think the next one might be Commissioner McGowan's. About confidentiality.
So my thought is if it was public before and we're not violating any state or federal privacy laws, it should remain so.
So just leave it as is, as it currently stands.
Yep.
All right. Commissioners, any comments with respect to that one? Very well. Next one. Ms. Prine, if you'd like to
Sure.
clarify that one, please.
So this came up again at the hearing on the 3rd, and staff agreed to clarify that service of process by publication would occur 5 weeks ending at the new protest deadline, so that those timelines would match up. Otherwise, without that clarification, those 5 weeks would have to run before the application, and that adds 5 more weeks to the process. And we've already stretched the process out. So it's just a clarification as to when we expect publication to run.
And I had that in my notes as well. So if that clarifies that, that was a concern I had of adding 5 weeks to process. So is that language that will be added here, or where will we?
Do you want that in the statement of basis and purpose, or do you want that here? I think probably in the rule to make sure that it's clear. And we would just add that to the end of that paragraph to clarify.
Okay. Do we need to have this particular wording set forth today? I see our attorney's heads going up and down, which I guess that means yes, we do.
My intent was just to add the wording that's in the comment, just as a clarification of when the 5 weeks would end. But I'm happy to change it to whatever we need it to be.
Fine the way it is, as long as the rest of the commissioners are okay with that also. And Mr. Davenport. Does it work? All right. Commissioners? You okay? All right. Yes, would you like to take a brief break?
Sure.
Okay. 10 minutes. can find their seat, we'll get started. I believe we're on to page 7. So I was going to ask first if maybe if Ms. Prine could give us a little context around the comments, and then we'll take it from there. If that's okay, Commissioner Overture.
Okay, I claim this one, so I can,
All right.
yeah. so-
Very well.
So this one was mine. I'm not quite sure why we are striking this language at the end of this rule about that has a time frame about when the notice needs to be provided to CDPHE and to Parks and Wildlife. And so if there was a thought behind that, I would be curious to hear it. But my proposal was to, if we don't want it to be at the same time that notice is provided to the commission, then saying that notice should be provided to these entities at the same time notice is provided under this rule.
So how would that, so help me out, how would you like that? If you added that, how would that read then? Oh, wait. Sorry. The director's shaking her finger at me.
Yeah. So the reason that line was stricken is because we do not provide notice to the commission. That's why that part was stricken. It wasn't a timing issue. It was just that that's not actually happening. And so it's in the rule, and we were trying to clean out anything that's not actually going on.
Okay, so I think then that makes sense. And I think there is value in having a time element on when that notice must be served. And so my proposal of adding the language, which would simply be sticking it at the end of that rule, would provide that CDPHE and the Parks and Wildlife get notified at the same time notice is provided to any other party.
So could you read that?
So it would say, for purpose of, I'll just start down at the Colorado Department of Public Health and Environment and the Colorado Division of Parks and Wildlife for applications made under subsections B1 and 3 of this rule, comma, at the same time notice is provided under this rule, period.
Okay, we're good with that? Yep. All right, thank you. So we'll make that change as worded. And forgive me for asking, Commissioner Overture, but I think it's important that we get the right wording plugged into this.
Sure.
At this point. So, okay, can you give us some context around the next one?
Mr. Chair, you heard a lot of party comment around how to alter 508, which is our local public forums. The staff had not done anything with these rules. We didn't feel like it was part of the scope of this particular rulemaking, but because you had so many parties requesting edits and adding language and just general comments about this, I added that just to make sure that the commission had an opportunity to weigh in if you so desire.
Which I think Commissioner McGowan was item 5 in our list. So commissioners, is there any reason, I mean, this may or may not be, to me, it seems like it's out of the scope, but I don't speak for the entire commission. Do we want to take this up?
May I speak on this
Yes, Commissioner Overture.
I do think that it is outside the scope of this particular rulemaking. However, I also think that Rule 508 is fundamentally flawed and does not reflect the reality of how this commission conducts its business and is in desperate need of reform. And so I would request that we undertake a separate rulemaking, which is confined only to this issue about when public hearings happen and how they are triggered. I think my proposal would be to simply delete all of Rule 508 and include a sentence that essentially says the commission can at its discretion call a public hearing to obtain information from the public about any matter that's before it. So I think it could be a simple rulemaking that we could conduct in the course of one of our normal hearings. But I would like us to address Rule 508 sooner rather than later, even if we don't address it in this particular proceeding.
All right, so noted. Commissioners?
I'll say.
Yes, Commissioner Hager.
I would agree it doesn't fall in the scope of this rulemaking, and I don't want to include it in any changes today. And I'm not, I don't feel quite as strongly as Commissioner Overturf did about it being completely flawed. But I think what we have seen is frustration and an inability for it maybe to be used practically as we start having a lot more public involvement. And so I would agree with Commissioner Overturf that we need to address that. It's a serious issue. We hear it from public comment. We hear it from local governments all the time. And so I would agree with Commissioner Overturf that we need to revisit it at another time.
Okay, so the engineer in me says by when? So by when? So when are we going to take this up? Do you think it does?
Hearing docket.
Sorry, Commissioner. Yeah. I don't want to. So I think that obviously but I don't think we want to set the date. But do we need to do that something that we could work into our schedule for the next?
Mr. Chair, really quickly,
Yeah, Commissioner Hager.
the other thing I disagree with Commissioner Overturf on is I don't think it'll be simple. And I don't think it'll
I would
be
agree
easy
with
to
that.
insert into a regularly scheduled hearing.
Yeah, I'm not sure we could put it into a regular, but I do think that we probably need to work to set a time within the next, 6 to 12 months that we undertake to review and redo 508.
If I may.
Yes, ma'am.
Forgive my hesitancy. It has more to do with the timing in which we're existing over the next 3 to 4 months than the substance of the rulemaking. I do think it will be a longer conversation to get there. There are a couple of other significant changes coming. I mean, we do have a rulemaking ongoing right now on school setbacks. We're all viscerally aware of what's going on with the election and the upcoming change in leadership at the governor's office. And so for me, the next 3 to 6 months may not be the best time to try to initiate a dialogue. That being said, we could certainly, maybe after the first of the year, start stakeholder conversations about what this could look like and report back to the commission in maybe March about where those conversations have gone. I think that might give me or whoever, or really Mike, actually, sorry, Mike. He's not in the room right now, which is even better.
Yeah, but throw him under the bus.
Listen, yeah. A better feel for what that process could actually look like. It's a little bit foreign to me to predict whether it would be something we could wrap up in a few months or whether it would turn into a much bigger conversation. And again, we hadn't done much digging into this issue. I recognize the flaws in it as it relates to how does it operate in the current technology development scheme. That was fairly inarticulate, but anyway, that would be my suggestion, is maybe after the first of the year, we can convene a couple of conversations about what would be meaningful or helpful changes to this rule.
And perhaps would it make sense that we do it at the point in time that we finish with the school setbacks? And once we're finished with that rulemaking, and if that drags on into the second quarter or something like that, then once we complete that, then we'll address this one. Commissioner
Benton, I have complete faith in this commission to wrap this up while I'm on maternity leave. So to be real clear, my hope would be to have the school setbacks wrapped up before the first of the year, which would then give us the holidays to, take a real deep breath before jumping into another interesting topic.
Happy with that. Commissioner Overturf with that one.
Just one other thing that I'd like to say is that I think if the conversation is framed as, here's this 8-page long rule, what would you change about it? Yes, there's no reason why this rule needs to be 8 pages long. And when you look at the way that most other commissions, how they invite or provide the opportunity for public comment hearings, it's one sentence. And so I think there's, I think framing the conversation as we were thinking about moving to, you can ask for a public hearing and the commission will decide whether or not to have one. What do you think about that? I think, I don't know if everybody else agrees with that. This is just one commissioner speaking, but I think that may help to focus the conversation, because I agree there's a lot here. And I think that's one of the problems with this rule, is that it is so prolific.
If I may, Chair.
Yes, Director Murphy.
Commissioner, I agree. And part of my hesitation around all of this is that staff hasn't done any research into what other ones look like. And so before kicking off stakeholder conversations, which means I probably will ruin more of staff's holidays, which is perfect, right? Like that's my number one prerogative, with really digging into and looking at how to meaningfully provide the opportunity to the commission and understand what sideboards, if any, would be appropriate. So.
Very well. I think Commissioner Overturf, you're okay with it, sort of the timing on this. It sounds like we'll take this up after the first of the year and look at the stakeholder process and undertake at some point in time. We will, not in the next 10 years, but before that, we'll undertake to redo this rule. Okay?
Mhm.
All right. So on the next is on page 12. Again, Ms. Bryan, if you could sort of set us up for that one.
Yes, Mr. Chair, this also came from party comments on the 3rd. There were a lot of comments about intervention by right, who has that right, and the standards that have to be used to intervene by right. Again, there was just a lot of conversation about this. On the 3rd, there was nothing specific from, at least from my notes, as far as language. It was more an opportunity for the commission to consider whether intervention by right should be expanded, primarily to neighboring local governments or other entities.
I've forgotten. I know there was something about it. This may or may not have been about providing a definition. And that's not this one, I don't believe. I'll have to look on my notes for that other one. Commissioners, is there anything that we would like to take up with respect to this?
I would like to.
Yes, Commissioner Overturf.
So there was actually a proposal that was submitted by the allied local governments that was alternative rule language that I think streamlined the pleading requirements for those entities who are intervening by right under the existing rules without making any changes to relevant versus affected local government. This would still apply to relevant local government. I'm sure we could get I don't know if everybody else held on to this piece of paper that they got like 3 weeks ago, but we can make copies and provide them to the other commissioners if that would be useful. But I think there's a lot of value in this proposal that was presented by the allied local governments. In my experience, where there are entities who are provided the opportunity to intervene by right, the pleading obligations that are placed on those entities are significantly lower because they're intervening by right. We've already decided that we want them to be part of this conversation. That's kind of the default. And so I think given that there's been some confusion about how these standards are applied to relevant local governments, that streamlining the pleading requirements will result in less confusion and ultimately assist in the streamlining of our hearings process. And so I would support the changes that were presented by the allied local governments to the intervention by right pleading standards.
For one, I don't have a copy of that, so.
I can hand it to you right now.
Mr.
and then we
Chair?
can make you a copy.
Yes.
If you would like to skip past this and come back to it, I can make copies of that for everyone so that everyone's working off the same thing.
I think that works. I do have a simple request that unless I think this intervention by right is paragraph B. Is that correct, Commissioner Overturf?
Yes.
Okay, in paragraph A, where it says these rules in order for, strike the words in order. I don't think they're really necessary.
I'm sorry, can you repeat
What?
what that is?
So in part A, it says information to demonstrate that the person is a protestant under these rules for the protest to be accepted by the commission.
Got it.
Change that wording. While we're making copies, then we'll go to 14.
Mr. Chair, I just want to say, because I know we're going to have some discussion around 509. I'm a little bit torn on this. I think that if we end up limiting intervention by right to very specific entities, and in this case, the staff's proposal is that it's a relevant local government and 2 named state agencies, I would agree with Commissioner Overturf. There's no need to then go on and add some sort of qualification on that intervention other than to show that you're entitled to intervene by right. I just think at some point there has to be early in the process, there has to be a demonstration or an identification of the specific issues that are of concern to give staff the opportunity to address it. So I think I'm generally okay with the concept of not qualifying the requirement or the permission granted by the rule to intervene by right if you fall into a specific category. I think we then have to just deal with, all right, what's the process after that?
Is that with respect to the PJ13 comment? The upper one? Consider proposed.
And I would not be, I would change my comment if we were going to expand the category of those who can qualify as parties who can intervene by right.
Okay, so I think we'll wait till we see this wording and take a look at that. Can we address the next one? Discussion read public issues and potential impacts. Ms. Bryan, where did that come from?
Mr. Chair, I think that came from a commissioner comment that I received. The downhole issues versus surface issues.
Yes.
Are we still on 509?
We are, we're looking at 509, but we're going to go on to the next one and come back.
But you're asking about that comment? That's mine.
Okay, yeah,
Want me to go there or are we coming back?
we can go there and then we'll come back to that.
This language is also implicated by the language that we're going to be looking at all together. So we may want to just skip 509.
All right, sounds good. Oops. Page 23. Some context on that one, please.
Mr. Chair, this came up from parties on the 3rd, and I believe a commissioner also raised the question about why the word will is being changed to may. And again, that is just reflecting how business is currently being conducted. If the director must issue warning letters, corrective actions, for every identified issue, we would need a lot more staff and a lot more time. So we triage enforcement issues and deal with the most severe first and foremost, and that process goes through review by staff. Therefore, we opted to change the word just to make sure it's clear that not everything is immediately issued an enforcement action.
Mr. Chair, that was
Commissioner Hager.
that was my comment, and I believe, I understand that's the way things go, and I guess I just wanted to bring out that, is that clear enough in the statement of basis and purpose? I just don't want it to seem like we're not issuing violations.
So what I heard is that you're okay with may and not will.
I think so, because all we're saying is that I guess I'm looking for clarification. All we're saying is that we're not necessarily going to go through all the paperwork.
Yeah,
No?
I think.
Commissioner Overturf.
I think, I'm not surprised that this is the way that things currently are in real life. I think that any kind of agency that's tasked with enforcement matters exercises some degree of kind of prosecutorial discretion about deciding which violations it's gonna pursue and which violations it's not going to pursue, and how that works. I think that's very typical for all agencies. I think it's important for us to have this conversation because I think this is, I think it may look as though the commission is radically changing the way that it conducts enforcement actions, because the existing language, I think, would lead a reasonable person to believe that we were issuing a warning letter or a notice of corrective action for every single violation that we encountered. And I don't know that that was actually the case. So I don't think it's just that we're not doing the paperwork. I think it's that there are certain circumstances in which we're not pursuing enforcement action against people where we have encountered violations. Is that accurate?
Director Murphy.
So I think we should make sure we focus on what is being issued, and it's a warning letter or corrective action. And so corrective action or a field level inspection report. And so I want to be clear that I don't think that this is impacting when staff is issuing the notice of alleged violation. It's kind of that precursor step. Is that fair? So I guess what I want to assuage the concern that this is a wholesale change to how staff is either issuing notices of alleged violation, or that staff is not issuing notices of alleged violation in the circumstances in which staff believes it's appropriate. And for NOAVs, 522A already provides that kind of discretion. And so I just want to make sure the commissioners are fairly focused on the fact that this change relates more to when a warning letter may be issued or when a corrective action inspection report may be issued by staff to kind of resolve it on the front end. Does that help at all?
Can I just ask a follow-up question?
I'd like to, before you do, I'd like to provide you from the operator's perspective. We get corrective actions all the time. It's not, if there's anything that needs to be done, we get a piece of paper that says this is what you need to do. So I'm fine with the word may, because it's another step that can be taken. We don't, as an operator, I've never seen the staff ignore anything that we've done that doesn't require corrective action. So I don't know if that helps you, Commissioner Overturf. We get a piece of paper and we have to address, and we address it as if it comes from the director anyway.
So my question was, does the staff currently issue a warning letter or an inspection report? What proportion of, if you go out and do an inspection and you find things that are not up to snuff, do you issue a warning letter for each of those inspections?
Warning letters are fairly constrained in the circumstances in which they can be issued. And so, and I'm flying a little bit by the seat of my pants, is that there hasn't been a prior violation for that particular rule. When we move into the realm of corrective actions, that's where staff is documenting its expectations for the correction of a problem.
And do you do that for each inspection that you conduct?
I would say for more, I might call on Mr. Leonard to provide a better, more precise answer.
focus myself here. So an inspection that has corrective actions, we consider a corrective action inspection a warning letter. Does that answer your question?
My question is, let's say you go out and you conduct an inspection and you find 5 things that are wrong. Do you issue either a warning letter or a corrective action required inspection report for each of those items? Is that your typical practice, that when you conduct an inspection, you do provide some documentation acknowledging the failure to comply with the rules to the operator when you find
Yes.
them? Okay.
Yes, it would be a single document with the 5 corrective actions on it.
And that's not going to change if we change this word to may,
No.
right?
So, Mr. Chair,
Yes,
just
Mr.
some
Anger.
background. I'm comfortable if everyone else is comfortable. And the thing I was trying to address is we hear in public comment all the time that we don't make enough inspections and we don't respond to complaints. And these warning letters and inspection reports are public. And so I just want to make sure that that stuff is happening. It looks like it's happening. It's apparent that it's happening. And if everyone's comfortable with this language, that's not.
I'm more than
gonna happen.
happy to testify under oath as an operator as to what we get for corrective
I'm
action.
not suggesting that the operators aren't. I'm suggesting I want the public to know that they can find that information, that those complaints are addressed and filed and public information. And we're not going out inspecting sites and not documenting it or not asking operators to do something.
Mr. Leonard, is everything that you do is a matter of public record?
Yes.
Yes.
Okay.
And so
I don't think anybody's disagreeing with you, Mr. Chair. I think there's value in having this conversation in public so that members of the public understand our rationale for why we're doing what we're doing
problem.
and understand the actions of this commission.
No problem.
So I'm good with the language if everyone else is, and that's the angle I was coming from with that.
Very well. So are we okay with the word may?
Yes.
Very well. Let's move. We're just waiting on the copies to be made to go back to 509. Thanks, Mr. Leonard. Let's keep going. Thank you. Ms. Bryan, can you give us some context on this one?
Yes, Mr. Chair, this came up at the hearing on the 3rd, and staff agreed to a language change to reflect when an order is deemed effective by the commission. There was some confusion about the language that we had drafted in G about the effective date of an order for appeal rights versus when an order is deemed effective, period. And so the language would change just to reflect that an order will be deemed effective upon commission approval, but the effective date for appeal would be upon electronic delivery or mailing.
To the relevant parties. Okay. So we all comfortable with the change in wording? Do we need to read it again just to make sure that we know exactly what's going in the record?
Can I just ask staff one
Yes,
question?
Commissioner
about this?
Overture, sorry.
The last sentence, is that if any party does not have the means to receive the order electronically, then the date is the mail date?
May I clarify?
Yes, Director.
You're envisioning if we have more than one party and we electronically submit to party A and mail to party B, what's the effective date for appeal?
And it's B. It's the effective date for the, if there's 10 people in a case and one person can't get notice electronically and they have to get it by mail, then the effective date is the mailed date for everyone in the case, right?
I think we can clarify that in the SBP.
Yeah.
Yeah, to just note that it's the later of.
I just want to make sure that people don't think there's 2 different effective dates. Some for people with email and some for people without.
I think Commissioner Overture, is that something you think needs to be clarified here?
I think Ms. Murphy's proposal to include it in the statement of basis and purposes just fine.
And I think I would also note that staff would do everything in its power to have all those happen on the same day, emailed or mailed.
All right. So I would request that we do have if Ms. Prine, if you don't mind reading again exactly how this will read, please. Okay. The change to the rule.
Final orders will be effective. Let me make sure I have this right. Final orders will be effective, will be deemed effective upon commission approval, effective for appeal upon electronic delivery or mailing to relevant parties. With a statement of basis and purpose, sort of explanation of your issue of the later of two dates.
Mr. Davenport?
Well, I'm sorry, thank you, Mr. Chair. I apologize, Ms. Prime. Where is that language that you just read going into the rule?
After this.
Okay. So the sentence after the reference to 3460-1087 is being deleted and changed.
To final orders will be deemed effective upon commission approval, but effective for appeal upon electronic delivery or mailing to relevant parties.
Mr. Chair.
Yes, Mr. Davenport.
I'm sorry. Let's move on. I may need to come back to this. I have to look at something very quickly, and then we'll come back to it if I think we need to.
Very
Is that
well.
all right with you?
Yeah, absolutely. Very well. I have several on page 37, starting with 17. If you could provide us with a bit of context on that first one, please.
There was some party discussion about requiring an applicant to own at least 51% of the mineral rights in the unit in order to be considered an owner who could establish an involuntary pooling application.
Yes, Commissioner McGowan.
So I think this was also put forth by the Allied Local Governments in Adams County. And I think after we discussed this, one, that it's probably outside the scope of the rulemaking, and two, I'm not sure it actually is legal based on statutory requirements for showing interest in when you want to pool. Would that be correct?
Definitely outside the scope, in my opinion.
Well, the statute, I think, the AG can tell us, but the statute, I think, says that any interested or any owner.
Right. Very well. So should we move on?
Yep. I just wanted to make sure that we were clear that we
Right.
heard the request, but that it's what our thoughts were.
That is outside the scope. Okay. The next one.
Mr. Chair, you also heard from several parties about a requirement that an applicant provide certain documentation or a certain number of leases or something to prove the reasonableness of their offer.
I think it's, sorry to jump in, but to me, it seems like that's another one that's outside the scope of the rulemaking. But I'll entertain any other comments.
I think it's,
Commissioner Jolly.
I think it's certainly a concern to a lot of people, but I do believe it's outside the scope for this particular rulemaking.
Very well. Commissioner Overturf?
I don't necessarily think that it's outside the scope, but it's not, and there are other kind of considerations about reasonableness that I think we're going to be discussing later. And I think the evaluation of reasonableness is within the scope of this rulemaking. But this wasn't my comment, and so I'm not prepared to go to the mat for it.
Okay. Commissioner Hawkins?
Yeah, I tend to agree with Commissioner Overturf. I think that if you're going to say in your rule that they have to be tendered a reasonable offer to lease, that it's not a bad thing to have somebody say, well, what is a reasonable offer to lease? And how do you know if it's a reasonable offer to lease? So I'm not saying you have to show me a number of different leases to compare it to, but I think there's some kind of a requirement to say that it is a reasonable offer to lease. There needs to be some demonstration that it's a reasonable offer to lease, and I don't know that I want to be prescriptive on what that demonstration is, but I don't think I think it's something that definitely could be questioned by the commission and a judgment made that it was not a reasonable offer to lease.
Commissioner Jolly?
I'd actually agree with that comment completely. I was talking about the first half of that sentence, consider requirement to provide certain number of leases. But yes, I think reasonableness is certainly up for discussion.
Mr. Chair?
Yes, Commissioner Boygan.
I want to point out that subsection C of the rule actually deals with reasonableness. And so if we're going to have this discussion, that would be, is it C or B? I guess it is. Well, whatever the renumbered section is, subsection. It was C.
Number C. It is now C2.
Yeah, okay.
No.
So
B2.
So if we're going to have this discussion, that would be the place to have it. And I'd like to also point out a couple of other things that one of the criteria in the current rule is such other lease terms as may be relevant. That's pretty broad and in my mind allows anybody pretty much to bring in anything they want. But I think it's also relevant for us if we're going to have this discussion to talk about how this process would work in determining reasonableness. And I think, again, in my mind, it's kind of up to an objecting or protesting owner or offeree to raise the issue. And if that person thinks that he or she has not been offered a reasonable lease, to file a protest and initiate a proceeding that challenges the reasonableness of the terms offered, and then the staff can deal with it.
Okay. Perhaps we can get to that, which for me is the basis of where it gets to where it's beyond the scope of this rulemaking to have that discussion and go into that in that much depth. But we can take that up at that point. Do we want to get through this, or now that we have 509, we can go through the rest, balance of the 530 comments and then come back to 509? Is that okay? All right. So the next one.
Mr. Chair, you heard lots of discussion on this at the hearing on the 3rd as well. I received comments from several commissioners about this issue. And the issue was about making sure that an owner can file a protest after having at least 60 days to review their offer, even if the 30-day protest deadline in our rule has expired. And if you recall, there was some language added and then pulled later based on the discussion. The statute allows someone to protest up until 3 days prior to a hearing. So the new statute requires 60 days to review an offer. So the task is to try to make sure our timing reflects that someone can have all 60 days to review and still have an opportunity to protest.
And that was one of my concerns.
I know, Commissioner Hawkins, this is a sticky one.
It is. You know, and I guess if we were going to, allow that party to protest 3 days before the hearing, then I don't have a problem with that. That's what the statute allows.
I think that's where I got to at that point, is it going back and forth, is it, that they have, it is accurate that they can protest within 3 days, the actual hearing date.
Yes, Mr. Chair, but from a process standpoint, the caveat to that is if someone were to come in 3 days before a hearing to protest, that hearing would be continued for the most part. I can't think of a situation that we would push it to you that quickly. So that would be sort of the only issue from a process standpoint to keep in mind. It doesn't affect the protest at all. It just means that we would have to continue that matter for our own internal workings to get things done.
So I guess, if I could.
Yes, certainly, Commissioner Hawkins.
If your options were to require a 90-day notice so that the person who got notice had 60 days to review their offer, and then 30 days to file a protest, file the protest 30 days ahead, or if you get a protest 3 days before the hearing, just continue it till the next hearing. Maybe you would shorten the time on the ones that nobody ever protested, and then you'd only lengthen the ones that actually did get a protest, because they would all get continued 6 weeks.
Yeah.
I don't know. It may not be a bad solution.
And the issue also came up when you think about it. If someone does the proper notice, they give the 90 days, individuals have 60 days to, at least 60 days. So they've got that 60-day window. I was wondering, was only give them up to the 60 days? But
it says at least 60 days.
Right, at least 60 days. So then that essentially says they could take the 60 days plus another 10 or 15 and then still file a last minute protest, which then continues the hearing, will then end up in a continuance. Because I was thinking about this as well, if they give proper notice, they only get 60 days. And then they have to file the protest within that 60-day time frame. But by saying at least 60 days, it opens the door for actually a longer period of time. And it gives the potential protestant a little more flexibility. So it was yours, I guess, Yes, Director Murphy.
It seems to me that we're struggling with a very narrow kind of category of protests, right? And so to me, a suggested solution would be that protests that are received less than 30 days before the hearing, which is the current or the proposed protest deadline based on these rules, but within 60 days of a protestant receiving their offer to lease, the protest will be accepted and the matter will be continued to the next hearing. I think that's the narrow issue that we're struggling with, and if that's helpful language to think through that kind of acknowledges the existing process and also the rights of a protestant.
And would that be a change in the wording there in 530(b)(1)?
I'm trying to figure out where it would fit. I think I wanted to first see if it was a lead balloon or something worth discussing.
Commissioners? Yes, Commissioner Overturf.
I think it's a fluffy balloon. And so I think there's more here to discuss. I think that, I keep returning to the language in the statute that says at least 60 days prior to the hearing. It seems to me that regardless of the statutory deadline of 3 days prior to hearing as the kind of protest deadline, that we as a commission have established a 30-day protest deadline in order to facilitate the administration of our docket. And so my inclination is to have the 60 days, that you should get 60 days before you have to decide to do something, before you decide you have to protest. So if we're going to stick with the 30-day protest window, then I think that would make it 90 days total. If you're going to stick with the very strict 3-day statutory, and then you're going to assume that they all get continued, I think it still has to be 63 days then before the hearing date, in order to provide that full 60 days. I guess my concern with that solution is that I tend to think about these matters as trying to stand in the shoes of one of the homeowners that comes and talks to us, who doesn't have any experience in this industry and doesn't understand the contents of the packet that they've been provided. I think having conflicting protest deadlines and having the automatic continuance that you think is going to be granted, but you're not sure, and so therefore you've got to plan to take these 2 days off work and then another 2 days off work 30 days from now, puts a lot of burdens on the sort of average person who may not be a sophisticated mineral owner. And so that's my struggle with the 3-day and automatic continuance approach.
Commissioner Jolly.
I pretty much agree with Commissioner Overturf, but for clarification purposes, is there any conditions on what you can protest if you just do it on the last 3 days? Wasn't there some discussion about that there would be conditional circumstances that you could protest if you wait till that last minute?
I think you're remembering the language that was agreed to by some of the parties, and then that agreement was swiftly dismantled as further discussion occurred in terms of and kind of on that basis of what could the scope of the protest be was part of the this dissolving of agreement on the language.
If I recall, it would be only if you hadn't been noticed, could you notice, only if you hadn't truly been noticed 60 days out, I think was the scope of the condition, was that would be the only situation where you could protest.
Right. Yeah, it was a case of someone who
you couldn't get to 58 or right towards the end and say, oh wait, my offer isn't good. That wouldn't be acceptable.
No, to someone who didn't, for some reason, their address was wrong or they didn't get noticed properly. Because as you started this thing, it says no later than 90 days in advance of the hearing date, operator has to notice folks. So you automatically, then they get, if they have to file that 90 days. So then they get 60 days to review it at least. And then they can file the protest 30 days in advance. And so that the discussion came up exactly what you said, is that, well, what happens if somebody doesn't get the notice in the mail and then they go back and, oh, and then I get it, then I find it, or then it gets delivered to them 15 days before the hearing, then you have that option. Then by the statute, you have that option to say, I want to file a protest, in which case it's common sense says you would want to continue that. I don't know if that helps with what Commissioner Overturf brought up or how we want to word this, but Director Murphy, I'll let you go first.
One other point, and this may help Commissioner Overturf's concern. I think that regulatory language generally can be hard for folks who aren't familiar with the particular regulatory process, and that applies in this arena as well. But by statute, staff is required to put together a pooling brochure. We have done that. I have been holding on finalizing version 2 of that until the completion of this rulemaking, such that that brochure can reflect in hopefully terms that are more understandable to folks who don't integrate with our process every day, what the opportunities are. And so I would also offer Commissioner Overturf that whatever comes out of this discussion can hopefully be better explained or more simply explained as part of that brochure to make the process more transparent.
Yeah, but there's also something else out in the public sector on pooling and spacing, and I can't remember who published that, but it's another piece of information available for people about what to do when you get pooling notices. And I can't remember the author, but it's been out for at least a couple of years.
There's tons of information out there. I tend to refer most, when we get questions, to Mr. Ray with Camro, when there are questions about pooling, because I think he tends to be a subject matter expert.
Right. Commissioner Hawkins?
No, after going back and looking at this, it does say that no later than 90 days in advance of the hearing date, the applicant.
That's the application.
Yeah, that's for the application, but the commission must receive evidence that the offers were tendered no less than 60 days. Yeah, so I'm trying to just make sure that there's the 60 days and the 30 days, and that's what seems most reasonable to me, that the offer be sent out and they have 60 days to look at it before they file their 30-day protest. I'm not sure exactly how that language needs to read, but that's the concept.
Which ties it to no less than 60 days, then ties to that option. It says after receiving an offer to participate and given at least 60 days to review the offer, which means that then, and that previous ties back to that, it says you have to give them an offer and give them 60 days to decide. So then it goes back to, well, should it be 63 days as far as what Commissioner Overturf said? Should we make that 63 days? Then they can file the protest within 3 days of the hearing. Is that where you're headed, Commissioner Overturf?
I think 63 is better than 60. I think that 90 is better than 63.
What you could do is you could say, well, you have to give them the offers to lease have to be sent out for the hearing notice, say 90 days.
Yeah, that's kind of what I'm thinking.
So no less than 90 days?
What's that?
Say that then you would, what I heard you say then is that you would change the wording up above. It says evidence that owners were tendered a reasonable offer to lease or participate no less than 90 days prior to an involuntary hearing.
Yeah, that's what I think that should say, so that they have a 30-day period to.
Well, actually, then they get 60 days.
File their protest.
They've got 60 days to review it and then 30 days to file a protest.
Yeah.
Commissioner Boygan.
Mr. Chair, I'm basically agnostic on the issue of whether they get that additional 30 days. I'm willing to go along with that, with what you just proposed. What I'm struggling with is the actual wording of this sentence, the proposed new language in A that says the commission must receive evidence that owners, plural, were tendered a reasonable offer to lease or participate no less than 60 days prior to a hearing. So if someone challenges the reasonableness of an offer to lease, does that mean that the hearing cannot be held, or that a hearing has to be postponed for everyone? I guess I'm struggling with why we have the word reasonable in there, because reasonableness could ultimately be a contested issue. It's in the eyes of the beholder. And to me, it raises the question of potential impact on the hearing itself. So what I would suggest is that we change that sentence to say that the commission must receive evidence that owners were tendered an offer to lease or participate no less than 60 days prior to hearing. And if you wanted to make that 90 days, I'd go along with it. And similarly, in the next sentence, I would suggest that we take out the reference to reasonable offer to lease and just say an application for involuntary pooling may be filed concurrently with the sending of an offer to lease or participate. Question of reasonableness will be determined
At the hearing.
yeah, or, I mean, it may not be challenged by anybody.
Yeah. So if someone
if it
doesn't
is-
like, with your following being that someone doesn't like their offer, then they can file a protest, show up at the hearing and present evidence that they did not, their offer to lease was not reasonable.
Therefore, the hearing is invalid.
May I, Mr. Chair?
Yes, Commissioner Overturf.
So I think looking at the statutory language, it says, an order pooling an unleased, non-consenting mineral owner shall not be entered by the commission under subsection 6 of this section over protest of the owner unless the commission has received evidence that the unleased mineral owner has been tendered no less than 60 days before the hearing a reasonable offer to lease upon terms no less favorable, waka, waka, waka. So I think the inclusion of the reasonableness language is consistent with the statute.
I respectfully disagree. I think I come to the opposite conclusion. I think that it's up to the owner to protest, object, raise a question, and then as to that owner, the pooling can't be confirmed until that protest is resolved. I don't think that owner, that owner's protest invalidates the hearing for everybody else.
Do we have to, the way the statute reads, does that have to be mirrored in this involuntary, in this rule? Can we take the word reasonable out of there? Or does that then violate the statute as it's written?
Yeah, I'm not suggesting that we in any way modify the language that Commissioner Overturf just read. I don't think my proposal does that. I'm just looking at the hearing process and the notice process and what the operator is obligated to do in order to trigger it. And in my mind, the operator has to submit offers to lease, and I'm happy to say has to submit reasonable offers to lease or participate with some time component, but it's up to each recipient of those offers to challenge what they've received. And if someone challenges, then they can do that by protest, presumably, which the commission would have to hear, staff would have to resolve.
What's the statute goes back to that and says the statute says no less than 60 days a reasonable offer to lease. So if this says tendered an offer to lease no less than 90 days, they protest, I mean, it's more or less still fits. In your mind, it still fits. I mean, because they show up at the hearing and say, no, they violated the statute because they didn't give me a reasonable offer to lease within 60 days. They gave me an offer. It was 90 days in advance, but it doesn't. It was $5 an acre for something that's worth 50,000 or whatever.
The sentence reads prior to an involuntary pooling hearing. So as it's written, if someone challenges the reasonableness of an offer that was tendered to that person, the hearing can't be held.
Or it could be held under protest, so could it not?
I don't know. I'm trying to avoid collateral attacks, and I'm trying to avoid bogging down the process. So I'm just not comfortable with the way the sentence is worded. I'm not trying to modify the obligation of an operator to tender a reasonable lease.
No, and if I could.
Certainly, Commissioner Hawkins. I think we're going to have to.
I don't know if it's going to clarify
here.
anything, but I think it's pretty obvious. We get just a little bit further down on this rule that there's a prescription, just like you pointed out, on how do we decide if it's a reasonable offer to lease. We look at the date, the term, the acreage, the rental per acre, the bonus payment, the mineral interest owner, and other lease terms. And it says also to look at the cornering and contiguous units that are, it says for the drilling and spacing unit in the application and for all cornering and contiguous units that are under the proposed lease. So I guess that it's just the terms of the lease. It's not really telling us to look at other leases. It's just telling us to evaluate those terms to decide if it's reasonable. You know, I think the key thing in my mind is that if somebody is going to be pooled, that they have the opportunity to protest on whatever basis. You know, we'll decide if their protest basis is valid or not. Or were the terms reasonable? Did they get the 60 days, etc.? But I think we need to just make it clear that they're going to get 60 days to evaluate their offers. And if they feel they need to, they can protest within 30 days of the hearing, or no closer than 30 days to the hearing.
Mr. Chair, could I just ask a question, and maybe this is for Director Murphy? So what happens then? Walk me through the process. Somebody gets a lease offer. Let's say there's 400 families in a proposed pooled unit, and 50 of those families decide, or those households, those recipients decide they don't like the lease terms they were tendered. So they file a protest. You've got a hearing scheduled for, well, you've got an upcoming hearing scheduled, and they meet the 30-day requirement for protesting. So what happens?
Under current protocols, which I don't think changed dramatically with the protest deadline changing, it just gives more time before one hearing to resolve it, is we convene a pre-hearing conference. The hearing officer convenes a pre-hearing conference, brings in all of the parties, sets out the issues in play. And so if reasonableness is one of those issues, evidence is brought forward by the operator to demonstrate the reasonableness of the terms. I think we can all recall recent hearings where there's been certainly a robust discussion about what's the best information and what's the best way to get that information to the commissioners about the reasonableness of leases, whether it's a summary list of what other lease terms are in the area, whether it's actually coming forward with copies of individual leases, whether there need to be time constraints on when those leases were offered or signed, and then understanding the different acreage positions that each lease covers. And so I'm hesitant to go too far in being prescriptive in these rules about exactly what that needs to look like. I think that it's what we have hearing officers for. This to me is kind of the classic example of what the pre-hearing process run by a hearing officer is in place to do on your behalf. And of course, there's an immediate feedback loop if the hearing officer has missed the mark in terms of getting the information that the commission needs to make a decision about reasonableness. So does that help?
Somewhat. So
sorry, I kind of lost track of the process.
No. It's so in my example, for the 350 recipients or owners who didn't protest,
mm-hmm.
they're deemed, well, they can't protest. They missed the deadline. So does the hearing then continue? Is the matter put on the consent agenda for those 350 owners that they're going to be pooled because they haven't protested, or is the hearing itself?
So currently, if one of the pooling orders that was approved yesterday, presumably there are a mix of non-consenting owners who received an offer to lease and signed the lease, or owners who received an offer to lease and did not sign the lease. And all of those folks who received notice of the hearing and did not participate are kind of subject to whatever the rules require. And so I think the foundation or the kernel of your question is, do we pool and determine non-consent without even if somebody has not come forward with a protest? And the answer is yes.
That's part of the question.
Yeah.
The other part is, how's the protest resolved for those who have protested? The hearing officer hears the matter and then
Queues it up for commission hearing. So we go through the pre-hearing process, get the information together. A number of times those cases tend to work themselves out, I think. And we try to work through that process. But in the event that we have a particular owner who's not interested in being pooled and, well, sorry, that's kind of a separate conversation. And an owner who disagrees with the terms of reasonableness, that would come to this commission to determine. And in that context, Commissioner Boygan, yes, there would be a decision. The focus of that hearing before you would be on this particular owner's interest and the terms provided to that particular owner. But for the remainder of mineral owners who received an offer to lease pursuant to that pooling application and notice, the order that the commission finalized in the context of the protest would also apply to those other owners.
Mr. Davenport?
If I may, the commission has in the past, when it hears a pooling application which is protested, entered that order as to all non-protesting, non-consenting owners, and then made provisions in that order for further process for the owner who protested if they find that protest to be valid. So the hearing is not continued. The order is not continued for all other owners if the commission finds the protest to uphold the protest. Additional process is provided to that one protesting owner, but the order is still entered as of the hearing date as to all other owners.
Okay. I think where I am is, I think A is intended to deal simply with process. And I was concerned that the wording of the proposed language could change substance, or at least could change the process in ways that were not intended. I think we're just really trying to deal with the 90 versus 60-day issue. And I think the wording, in my mind, creates unnecessary issues around that. And so I would suggest changing. I'm not even sure you need that second sentence. I think you could add on to the application requirement that the operator has to has to send the application no sooner than 90 days prior to the hearing, and must include in the application an offer to lease or participate. Whether it says a reasonable offer to lease or participate sort of opens the door to whether the operator has complied with the notice requirement. And I really don't want to go there. I think if a party believes that an operator has not tendered a reasonable offer to lease, then that party can protest. But I don't think it should invalidate the hearing.
I think we have to be very cautious. I don't think you want to include that lease offer as part of the application. I think the way you had it before may fit. And it says commission must receive evidence that owners were tendered an offer to lease or participate no less than 90 days prior to an involuntary pooling. Application may be filed concurrently. You almost don't need that next one. It says may be filed concurrently because now you're going to do both at the same time. You can strike that sentence.
I'd be okay with that.
Yeah, and then to get to your reasonableness, and we go to C, which actually ties to what you're saying. It says after receiving an offer to lease, which ties back to A, the rewording of A, an offer to lease, and given at least 60 days to review the offer. The unleased owner has if he doesn't have a reasonable offer to lease, then there's some things that we can use to determine that whether or not that's reasonable.
Right. I think C already deals with that. In determining whether a reasonable offer to lease has been tendered under the statute, commission considers the following, and that's where we get into the question of reasonableness.
Okay. Commissioner Hawkins?
Well, I mean, I respectfully disagree. I think including the word reasonable just sets the tone on what we expect. It doesn't change the process any. and it tells the people who are reading the rule that they should expect a reasonable offer to lease. And then what is the reasonable offer to lease is down in C, or how we judge it. But I don't think that that's going to change the process. If it's changing the process, then what are we letting somebody give a lease offer that's not reasonable? I think they should offer a reasonable or make a reasonable lease offer. And that should be our requirement.
Okay, so we have Commissioner Overture, and Commissioner Jolly, and then Commissioner McGowan. And then I think we're gonna have to get to a spot where we're just gonna vote on how this wording is gonna be, but everybody gets one more kick at the can here.
So I agree with Commissioner Hawkins, and I think the way that I read the statutory language is that it sounds like we cannot issue an order pooling an unleased, non-consenting mineral owner unless that owner has had a reasonable offer to lease in hand at least 60 days prior to the hearing. So if you offer them, if your offer to lease initially is, give me all your minerals and I'll punch you in the head, plainly unreasonable, they can't wait until a day before the hearing, provide them a reasonable offer to lease and be in compliance with the statute. You need to have 60 days to evaluate a reasonable offer to lease prior to the hearing. So that's why I'm in agreement with Commissioner Hawkins.
All right.
If I might, Mr. Chair.
Hold that thought. I'd like to hear what Commissioner Jolly and Commissioner McGowan has to say first.
That's the reason we're here today is it says a reasonable offer and you're supposed to have 60 days to review it. And that at least the spirit of the legislation, I believe, was to give us 60 days before you had to file a protest. It shouldn't be concurrent. How you work that out, I'm still, struggling with. But I think whatever we end up here with should be 60 days and I'd leave the word reasonable in. It's in the original statute. It's in the new statute. And it gets to it later here. And that's what it's all about, is getting a reasonable offer. So that's where I'm at.
Okay. Commissioner McGowan.
Thank you. I think I'm in the same place. I keep reading the statutory language, and it's clear that we're not supposed to enter orders of pooling until reasonable offers have been tendered. And so I think we're covering ourselves by being clear about the intent in our rule. This is our expectation before you come before us.
All right. Mr. Boygan.
Well, I can see where this is going. I still disagree that this language, I think this language is an invitation to mischief, but I think it's an invitation to collateral attacks on hearings. And on pooling orders, I could be wrong. I could be overstating it. So it may be that we can clarify it later on or in a different provision, because I really think that the purpose of this sentence is really to go to timing and not to substance of the validity of pooling proceedings.
Okay.
So anyway, I still don't like the way this language is worded.
All right, just a moment. Yeah, sorry. Okay. Commissioner Hager, anything you'd like to add at this point?
Nothing new. I just, I'm focusing on the timing. I think that's what this clause should talk about, and I'm okay leaving reasonable in there.
Okay. I think I'm in the minority with Commissioner Boygan on that. So my first request is that are we in agreement that we would make the offer, whether we use the word reasonable or not, increase that from 60 to 90 days to give people more time? Is that okay? All right, thumbs up on that one. The next one is that do we change the wording to say include the word reasonable in both? Oh, sorry, if we increase that to 90 days, do we then strike the next sentence, which says an application for involuntary pooling may be filed concurrently with the sending of a reasonable offer to lease or participate. Does that then become redundant, and can we remove that?
Well, I mean, I don't think it's, excuse me if I could, Mr. Chairman.
Certainly,
I
Commissioner.
agree. It is implied that if you're going to send them both in 90 days, you might as well stick it in the same envelope. I mean, or same mailing or whatever. But I don't think I think it's just clarifying that you don't have to have two different things. You could do it all at once if you want to.
So just, you're saying just leave it in
I'm saying
there?
it's fine. I don't think
All
there's
right.
anything wrong with that.
Commissioners, do we just leave it there?
I don't
Over
think
to-
we need it anymore
I
because I
agree.
think we're saying both things have to happen 90 days before the hearing. So they're going to be concurrent whether you want them to or not.
Okay.
Director Murphy?
There's certainly a scenario where an operator might file an application 97 days before and then send out notice at 90 days, but the May is permissive and.
Very well. So we'll leave it in there. Okay. So we leave it in there. Now we're on to, so there's two places to take the word reasonable, in or out.
Mr. Chair, I have another suggestion.
Okay, very well.
That might be acceptable, I don't know. And it may be that I'm the only one who's reading the sentence this way and everybody else is fine with it. So I could be overreacting, but another potential fix would be to leave the sentence the way it is. And at the end of the sentence, add affecting their interests. So it's prior to an involuntary pooling hearing affecting their interests. Then it's pretty obvious that you're just talking about, it's specific to an owner. But maybe that doesn't really fix the problem because anyone, to use Commissioner Overturf's example, even those who didn't protest could theoretically challenge the after the fact, the involuntary pooling hearing on the ground that the offers they were tendered were not reasonable. So that's, I guess to me, it still goes back to making this a condition to the hearing. It just troubles me.
Fair enough. At the end, I think we need to move on. So
okay,
at this point, we should, I guess, we voted on this in the past, sometimes show of hands, sometimes essentially an individual poll. I guess at this point, and we don't need a motion, but do we, so what's on the table is, do we include the word reasonable? And I'll ask for Ms. Prine to poll each commissioner.
But we're talking about, do we agree with the language that exists here with the exception of changing 60 to 90?
Yes.
Okay.
In A.
Yes.
So the
In A.
sentence would read, the commission must receive evidence that owners were tendered a reasonable offer to lease or participate no less than 90 days prior to an involuntary pooling hearing.
And then this following sentence also. And application.
Yes, and keep that sentence, yeah.
Yeah, and application for maybe filed with the sending of a reasonable offer to lease.
Chair Benton,
No.
Vice Chair Boygan,
No.
Commissioner Agar,
Yes.
Commissioner Hawkins,
Yes.
Commissioner Jolly,
Yes.
Commissioner McGowan,
Yes.
Commissioner Overtur.
Yes.
All right.
5-2, Mr. Chair.
Okay, so the word reasonable stays in. What's next?
Such a good question. This came up at the hearing as well, and I believe a commissioner raised this also. We are on 530B, changing that to read, upon a showing by the applicant, either at hearing or in 511 testimony that it has complied, blah, blah, blah.
Yes, Director Murphy.
May I suggest that that clarification be added to the SBP?
Works for me. Commissioners, we're okay with that? All right. What's next?
This is on B1A, Commissioner comment about adding clarification on directional wells versus horizontal wells. I don't understand all of the,
So I own that one.
everything in there, so I'm going to leave
I
that
thought that
alone for
was
you, Mr. Chair.
Yeah, sorry, the geek slipped out there a bit. But essentially, it would just say the location and the objective depth of the well. Specifically, directional wells will include the estimated measured and true vertical depth. And horizontal wells will include the estimated measured depth, true vertical depth, and lateral length. Purpose of that being is that, again, to provide more information for folks that aren't familiar with this, is what are they actually signing up for if they are looking to participate or not participate, and that ties back to sort of expense and risk and uncertainty associated with what's going to take place.
Yeah. I agree with that totally. I think it just clarifies if you've got a 15,000 foot well, and it's horizontal for 10,000 feet. I mean, at least it's clear. It's not like, okay, well, this is going to go to 5,000 feet or it's going to go to 15,000 feet. What?
Struck me in one of the last
Yeah, it just
pooling
clarifies
applications that we're going to drill a 15,000 foot horizontal well. Well, how deep is it? How long is it?
Right.
That sort of thing.
I don't have any problem with that. I think
All right.
that's good information for today's
Okay.
technology.
All right. Ms. Bryan, did you get the wording on that one?
Yes.
Okay. Yes,
Chair.
Mr. Davenport.
I'm sorry, Commissioner Morgan, go ahead, please.
I hesitate to interrupt Mr. Davenport.
You're going to let him speak?
Mm-hmm.
Okay, very well.
Just as a matter of procedure, I would like the exact wording read into the record. Ms. Bryan, I apologize.
Would you like me to do it again for you?
Yes, please.
I would suggest creating two subparts to that rule, one for directional and one for horizontal. And so for directional wells, information that would be required would be estimated, measured, and true vertical depth. So the second subpart would be for horizontal wells, the information will include estimated measured depth, true vertical depth, and lateral length.
Is that satisfactory? Okay. Now, Commissioner Boygan.
So I'm fine with those changes. I have a couple of other issues on this section that I wanted to at least raise. One is it asks for or requires the estimated spud date, but there's no outside date. So my question is, I guess this is a question for Director Murphy, and I think I already know the answer. Is there a duration of the effectiveness of a pooling order based on whether or not wells ever get drilled?
Typically, that kind of a stale pooling order or expiration of a pooling order has not been something that we categorically address. Certain operators have requested language forward to say that at a certain point in time, the operator would reoffer to participate because the information may have become outdated. So again, not categorically, but it has arisen upon the question and the issue, and this commission has issued orders upon occasion addressing a spud date that became stale.
Well, I'm sorry. I'll follow up, and then
Certainly,
Commissioner Hawkins wants to weigh in. A related issue is what happens if the well changes, if the objectives change, a variety of things could change. So again, I think we heard some testimony about concerns that operators are changing things on the fly or changing things after the fact. We don't really address whether what kinds of changes, if any, should go to the validity of the pooling order that was entered or whether it needs to be re-offered.
I think that's true, and I suspect that the commission staff have relied upon a mineral owner or an operator who's dissatisfied with the initial terms to come forward and complain and say pooling shouldn't apply. This pooling order should no longer apply because offer is stale or what was proposed is not what came to be. And I can think of maybe one instance in my time here where that's come up, but it has not been frequent.
Commissioner Hawkins?
I don't really know how much discretion we have to address that, but I share your concern. I think that the pooling, to be able to go out and pool something and then not drill it for 3 or 4 years is kind of silly. I don't like that. I actually think that it ought to be like a 2-year, same as a APD, or when the AP, maybe tie in something, if you're going to pool it and file an APD together somehow. I just feel like that's a reasonable way to expect operations to occur, and not just space and pool and tie up this acreage and now I'm gonna go look at something else for a while.
Okay. I have some concerns that we're, again, straying outside of the scope of the rulemaking. And this may be something we need to come back to, and I did a check with our attorney, and
No, I agree.
Also
I don't
asked
know
about
that it's in the scope of this, but it is a concern that I share as well.
yeah.
Okay.
Can we decide that it's within or not within the scope of this rulemaking to address that?
Mr. Davenport?
But certainly if you've included some provisions in that regard, you've implicitly decided it's within the scope. That I don't know that you need to make an explicit finding that it's within the scope. If you put it into the rule, you're finding it's within the scope. A discussion of is never a bad idea about why you find certain things, or whatever your decision is, to back it up with your thinking is always a good idea.
Well,
So I guess I'll leave it with is happy to go on with this as long as we have something specific that we want to add with respect to this area. It's something that we can provide for wording so that we're not here at 6 o'clock still debating this one.
Yeah, Mr. Chair, in an effort to move this forward, I'll suggest that we not consider language at this point, because I'm guessing that there are going to be other issues on this rule that people are going to raise that we're going to think need to be explored. The whole pooling process, in my view, needs to be explored. I don't think this rule is very adequate, frankly, for the age that we're now living in. So I've expressed my view on that issue, and that's an issue that I'd like to see addressed. And it would be helpful to get staff's input on the related issues of staleness and material change in the well that's been proposed. And another issue that I guess I'll throw into the mix is the question of including multiple wells in any specific pooling proposal, whether an owner can be required to consent or non-consent, or participate or not participate in 15 or 20 wells at the outset, or whether the elections have to be well by well. I know that issue's come up in the past, but
it has. Director Murphy? Yeah.
I would say it has, and I've made note of those two. I think they're two big issues.
It has come up times, and we addressed it within the pooling order. So when we actually had the pooling application, it was protested, we addressed that within the modifications of the pooling order.
Those are good considerations.
Yep.
I agree.
Okay. And if you're all right with that, we'll move on.
I'm okay.
Okay. And the next one, Ms. Prine.
Mr. Chair, you received testimony from a party, I believe, requesting consideration of requiring evidence with the application that includes a determination of the interest of each owner in the unit.
May I speak to this?
Yes, Commissioner Overturf, go ahead.
This was on my list. I think it is valuable that we're adding the language to B1 little b that says that the cost has to include both the total cost and the owner's share. I think that gets to some of the issues that were raised by this party. I also found it really compelling that we used to regularly require/receive this type of information about these are the owners and this is their particular share, and it's kind of set out in the order, in the pooling order, and that could help to alleviate some lack of clarity or some conflicts on the out end. And so I'm really curious mostly to hear from my fellow commissioners about what some of you with more experience in the day-to-day operations of the industry think about that requirement. The argument that, well, now we're doing stuff that is more broken up and it's bigger pieces and there's more people and so it's harder, that to me isn't a particularly compelling argument because the standards kind of in the statute are what the standards are. But wanted to have a conversation and get input from other commissioners about this proposal that was given to us by Incline.
Very well.
All right, I'll jump in,
Mr.
Mr. Chair.
Boyd.
I have at least two concerns with that. One is I don't think it's the commission's role to be making determinations of title, and I'm not clear on what the legal effect would be of specifying interests in an order, identifying interests. I'm not sure what that accomplishes and what impact it has. Is it an adjudication? Is it a according to our best information and so what? I'm just not sure what it accomplishes or that it's our role. And second, I'm sensitive to concerns by operators that their information is confidential, that they've done the title work and they're not interested in giving that away to third parties so that they can go out and compete with them in leasing up the unit. So I would oppose adding any gloss on what the statutory language already requires. I don't think the statute, I take the point that apparently the commission in the old days may have, in its orders, described the interests as presumably they were submitted by the operator. But the commission hasn't been doing that in recent years, and I wouldn't require it. I would leave it alone and let the commission determine what it wants to, let staff determine what they want to include in a given order in terms of interest.
Very well. Commissioner McGowan?
So I'm not expert, so this is going to be ignorant comment from me, but.
Not at all.
I don't know that I was really moved by the testimony from Incline because it felt like they were asking for that information for self-interested purposes. One, wanting someone else to do the work for them and find all the titles and then hand over the information. And it wasn't clear to me how I, as a commissioner, would benefit from that information in a hearing. Would it change my mind about a pooling to know how many owners there were and how much interest each of them had? I don't know I don't know. I don't know how that informs a discussion when we're talking about pooling. And then I guess my other comment was, is this within the scope of the hearing?
Okay. Commissioner Hawkins?
Well, I was trying to just go back and look at what the statute says, and I'm in the right paragraph, but I haven't found it yet. But
We can come back to you.
I think, I guess what I'm seeing is that the order should lay out who's participating, who's not participating, and who's non-consent, I guess, or something to that effect. I don't know that it necessarily requires that it lays out that you have 10% or 2% or.
Commissioner Hawkins, may I point you to the statute?
Or
Go ahead, Commissioner Overturf.
It's 116.7A, Roman numeral 2. And it says, each pooling order must determine the interest of each owner in the unit and provide that each consenting owner is entitled to receive. And then it goes on from there.
And I remember there was a lot of discussion around what that meant, and it's whether or not they're an interest, I think, was not the specific number, but it's whether or not they have an interest. I think, and I can't remember the whole discussion around that, around the sort of the context of how that was worded, but I don't think it's meant the exact number. And I would look to the director. I think that there's some different interpretation, and I can't remember exactly how that came out.
My recollection is that one party said determination of interest meant by percentage, and other parties thought the determination of interest was more in this category of whether they're consenting and non-consenting.
Right, consenting or non-consenting. There you go. Thank you.
And if I could, I think I kind of went, at first I was trying to go along with, yeah, maybe we should lay out what the percentages are, but I think it's more reasonable for the commission to just make it clear that this is a party that's is participating, you know, or is going non-consent. And I think that's
okay,
about as far as we really need to go.
All right. Mr. Jolly, anything you want to add? No. All right. Mr. Hager?
I agree with Commissioner Hawkins, and the only thing I would add, I think I was leaning before at the start of the hearing towards, yes, we need to add this. I don't understand why we don't anymore, but I was compelled by, I don't think that industry, the argument is necessarily that it's harder. It's that it is harder and more expensive, and it is a huge part of business now, and making that public does, put all that information that they've already spent money to acquire out there for free for anyone else. And then I think a second thing for me is if I was an interest owner, I'm not sure I'd want that information public, or at least that readily available.
Very well. I'm hearing a general consensus that we don't include anything with respect to that, and we just move on. Is that okay?
I mean, if anything, there could be some clarification that it is, and where am I? Just clarification that it's going to provide who's non-consent and who's consenting, or something to that effect. I mean,
we may have that already. So I don't have all these rules memorized.
I know, I don't either.
So I'm with Commissioner McGowan and Commissioner Boygan that I think this is outside our scope, and I just as soon move on.
Can I just make a recommendation?
Sure, Commissioner Overturf.
If having orders clearly identify, if there are 10 parties, these 5 are consenting and these 5 are non-consenting, or these 5 are participating and these 5 are non-consenting, that it seems to me that that's something that our hearing officers could include in pooling orders today if they wanted to, and that would not necessarily require a change in the rules here today. So just something for our staff to consider.
Director Murphy?
Yep.
Just checking. All right.
Great.
All right. So I think we'll leave it that will be in the pooling orders who consented and who didn't consent. I think that there's some wording to that effect already in there somewhere. That we have to provide that. So as you said in the statute. 38.
Mine aren't numbered. Is this adding the list of reasonable offer to lease?
Yes.
Okay.
So
The first comment is, the context around that first comment on 38.
right. So this is a commissioner request to consider adding to the list of things that the commission will consider when determining a reasonable offer to lease.
and this was my comment, so I will claim it. The items that I've listed here are things that I heard parties bring up over the course of the rulemaking as criteria that we may want to utilize in assessing the reasonableness of an offer to lease. There are some that I feel more strongly about than others. So for instance, I think based on some of the feedback that I've heard in public comment in my time as a commissioner, that responsiveness to inquiries from mineral owners would be an important consideration for us to add to our assessment of reasonableness. I think clear presentation of information may be solved by some of the new standards and the brochure that Director Murphy is working on. And then also the performance of reasonable diligence in identifying owners' last known addresses. But I thought some of these other criteria were interesting as well. So I do think generally that there is value in providing, notwithstanding the catch-all provision in subpart E, I do think there may be some value in providing some additional specificity around the criteria that we will utilize to assess reasonableness of an offer to lease.
Your comments on this, Commissioner Boygan.
Thank you, Mr. Chair. To me, this is a slippery slope, and I am not necessarily opposed to the concept of adding either more clarity or even some more teeth around the concept of reasonableness. Again, to me, it goes to this issue of bringing this rule into the modern era. If we're going to be adjudicating the interests of owners based on some concept of reasonableness, and you know, leaving it to the operator to determine what's reasonable by giving them a form lease, I have some concern around that. At the same time, I have some concern about opening the door to using the commission to negotiate leases. And it gets to, for me, the concept of what's the purpose of this provision. We want to give owners a reasonable opportunity to get value for their interest and to enter into an appropriate transaction before they suffer a penalty. And so if we're going to penalize them and put them to the choice of leasing or participating or being pooled, to what extent do we need to sort of even the playing field for owners who get these printed form lease offers or offers that may be I'm trying not to use a pejorative adjective, but offers that are not fair. You know, to what extent should we be involved in refereeing that process? It's a tough issue for me. So I would put this in the category of the same as the other ones we've just discussed. I'd like to hear staff on that. I'd like to see what other states have done. I'd like to see what proposals are. I don't necessarily agree that the specific criteria that have been offered up are good or bad. I'm not sure they really solve the problem. I think we really have to think about what's the role of the commission here in determining reasonableness. So I'm at the moment, I'm not in favor of adding anything to this rule, but I'm in favor of continuing to consider the issue.
Commissioner McGowan.
I am interested in knowing, though, if there are best practices out there or if there are some suggestions by the group that represents owners. I'm sorry, I can't remember the name of your group. My guess is that they've thought about this much more than we have about what's helpful to an owner to know that they've been given a reasonable proposal or a reasonable lease agreement. I don't know if these are the magical things that help somebody understand or the commission understand, but sometimes it is helpful, again, to let folks know what it is a commission we would look for in determining whether or not you've made an attempt to make a reasonable offer and provide adequate information to someone who's not well-versed in the world of oil and gas leases, to understand I've been given a reasonable offer. So I am supportive of this. I don't know if this is the answer right now, and I don't know if we can make that determination right now, but I'm interested in Commissioner Boykin's suggestion that we look at what other states do, perhaps what are some of our partner groups have looked at, but maybe we're not ready to add it right now.
Okay, Commissioner Jolly.
Speaking as a mineral owner, I've never been force pooled, so I've not negotiated this subject. It's a big stick that is handed to companies to be able to force pool, and we are the referee the way the rules are written. But I think our rules have gotten aged or stale, and I think we need to, and I think we will be looking at all of 530 in the future from what I sense being on this commission. And I don't feel prepared today to put certain things in there. I think they're all good ideas, but I think this is another rulemaking coming down the road. And it's great topics, or I think it's opened our eyes to what needs to be discussed in the future, hear from both sides on it. But just to add one or two things here today is probably not going to change. It's going to be revisited soon, I'm sure. So I think rather than stray too far away from the scope of what we're trying to do today is make a concentrated effort to look at the whole 530.
Okay.
Hopefully in the near future.
I basically have a couple of concerns. One is the question of scope again. And secondly, the more we add to this, at what point do we cross the line and get involved in contractual negotiations between the operator and the mineral owner? And we start adding, well, you have to have this, this, and this. It becomes very prescriptive. And then we're essentially involved in their business negotiations, and I'm not sure if that's a place we should be. So I think that this is, again, it probably deserves some additional insight into looking into what other pooling statutes are out there and what else is included. At this point, I'm not prepared to and don't support adding anything else to this. The way it's written, as it stands as it is written. Mr. Ager.
I guess I disagree a little bit. I think this is within our scope to try to clarify things for forced pooling for people. I think it is a slippery slope, and we could get into contracts and things, but I also feel like there's a couple of things on this list that would be potentially easy to add and I could get behind today. Responsiveness to inquiries. We hear that too often, that people call and can't get the information they need. And I don't think that's something that's hard to add to this. A development timetable to me seems to address some of the other things we were discussing previously. And then lastly, just reasonable diligence in identifying the owner's last address. We've heard that too often too. I think it's a slippery slope, but I think those are, I could get behind at least adding those three things today and probably addressing something immediately instead of kicking it down the road.
Commissioner Hawkins.
I tend to agree that one of the things that I brought up a while ago, the timeliness of development, I think laying out it does say, when do we expect the well to be drilled and arranged? So I guess there is a timetable that's put out there, but I recall a hearing not long ago that the timetable was way passed over before any well was drilled, and the forced pooling still held, for that party. So again, that may just be something we need to add or address. I think the number of wells that we're drilling nowadays, 22 wells kind of back to back on a pad, Are we force pooling all 22 wells? And when are they going to be drilled? Or how long is the force pooling order valid for before the well gets drilled? Those are things that I would really like to see addressed, but.
All those are things that potentially end up going in the pooling application and the notice as opposed to a lease offer.
Right.
And I think that's where I get to this, is that when I look at this, and I'd have to agree, well, those make a lot of sense, but when I'm reading the ones that you'd like to have in there, to me, I wouldn't want to put that in an offer to lease. It's
Right.
going to be in the notice of the pooling order. It says, we're filing an application to pool this lease. Here's our, we plan on drilling X number of wells in this time frame. We've drilled 1 or 2 already, and that's why we want to proceed. So I think to me, it muddies the waters by trying to jam this into what's determined to be a reasonable offer to lease. Commissioner Boygan.
I would, Commissioner Agar has persuaded me on adding a couple of the items that were mentioned. I think they're consistent with improving the process for owners, especially those who are very unsophisticated in these matters and are trying to figure out what's going on. So I could support that. As one who has negotiated many oil and gas leases on both sides of the table, I have some concern. There's almost an endless list of issues you can get into in an oil and gas lease, depending on which side of the table you're on and what your objectives are, what your concerns are. And so I just want us to carefully consider, if we start getting into substantive lease terms, where that's taken us. That's all. I don't disagree with Commissioner Jolly's comment about the fact that to a certain extent, we are a referee. We have to, if it's challenged, we have to determine reasonableness. But to start getting into the substance of reasonableness, this really depends on the situation. So I could get behind Commissioner Agar's suggestions.
And I agree. Does it make more sense though when you think about what you've asked, which is things like development timing, responsiveness, maybe responsiveness to inquiries? Is that's
instead of
I would struggle with that, where that fits into a lease agreement, and you're going to say, here's a lease agreement, and we've had 15 different inquiries about it, but I don't have as much of a struggle with it if it's some of that starts to go into that section 530 little b, where it's things about receiving an offer to participate, and there's a few more items out of it that are taken out of that list and plugged in there instead.
Mr. Chair, I would just offer, I agree with that, but I think the concept of responsiveness here was really intended to address providing contact information and an easily identifiable source of information to the owner.
Which is item D.
In the offer.
All offers to lease or participate must include contact information for the representative of the applicant to answer questions and the commission's brochure describing pooling procedures and the owner's options related to pooling.
May I, Mr. Chair?
Certainly, Commissioner Overton.
I think my thoughts from that were that if I agree that the provision of a contact is already included elsewhere in the rule, but if countless voicemails are sent to that contact information and no one ever calls you back, I don't think that's a reasonable offer to lease if no one returns your calls and answers your questions. And so I think including that as a component of reasonableness, my desire with including that was really to capture those types of situations, which we've heard about in public comment, where if somebody tenders an offer to lease and then you don't get any follow-up, they don't answer any of your questions, that is, I think that's something that we should be able to take into consideration when we're assessing reasonableness.
And there was some discussion about that. I think the contact information is that you get a live person. You don't get voicemails that never get return calls, but maybe where there needs to be some more specificity to that.
Mr. Chair, I'm just struggling. I don't necessarily disagree with Commissioner Overturf's basic point that operators need to be responsive. I'm just not sure how that fits into a lease itself. You can put a provision in that says that the lessee will be responsive to inquiries from the lessor. That could be in the lease, but whether or not they honor it or how you determine responsiveness after the fact is a different issue.
So I think there's some, hearing that there is some desire from my fellow commissioners that we do a more thorough dive into what sorts of criteria we should be using for assessing reasonableness. I agree with Commissioner Jolly that it is well within our role, and that we serve almost a consumer protection role when it comes to this particular issue. I wonder if there isn't, if we skip down to the next comment was the proposal to add a general provision that says all offers to lease must be negotiated in good faith. I think that would respond to some of these issues that I've also listed in the reasonableness criteria. It may be that that's something that we could include to get at some of these issues while still leaving the door open to having a more detailed conversation about reasonableness and how we determine reasonableness in some future rulemaking. So just to put that out there as an alternative that may.
So what you're proposing is that we leave the wording as is and then add Part E. The Part E.
Yes. Putting that on the table as an alternative, recognizing that there's some heartburn about addressing the criteria today.
Definitely think that's a great way to go, but I'll leave it to the other commissioners to decide and comment.
Again, Mr. Chair, what I'm struggling with is this process here. You've got 90 days to send the offer out, and then you've got 30 days before the hearing to protest. So are we suggesting that during that 60-day period, that a landowner and owner can try to engage the lessee in negotiating lease terms, and the lessee says, these are the lease terms. You can lease, or you can go non-consent, or you can participate. And so then the owner can protest on the basis that the operator was not negotiating in good faith, and that's a basis for not pooling that owner or determining that the lease offer itself was not reasonable. I'm just not sure how this is actually going to work.
Commissioner Overturf, can you share some insights on how you think that might work, please?
Sure. So if you look at our rules, there are a number of instances where we impose a general operate in good faith requirement upon operators. So for instance, under Rule 306A, it says that the operator shall consult in good faith with the surface owner. There are other instances where we impose this general good faith requirement. So I think determining what is and is not operating in good faith is going to be a case-by-case situation. I think an instance where an offer to lease is tendered and no one ever returns your phone calls and the contact information is busted, it just like sends you to a Chuck E. Cheese or something, I think that would obviously be not negotiating in good faith. But I feel, given that this is a standard that we've utilized elsewhere in our rules, I feel comfortable including it here.
Okay, other commissioners? Where do we want to go with this? Mr. Jolly?
Okay.
Yep.
Commissioner Everturp, what do you mean
Commissioner
about when you say you feel comfortable just leaving it in good faith and not being specific, or being specific and adding that as a qualifier for negotiating in good faith?
My proposal would be that we add let me get back on my rules here, that we add a new subpart D that says all offers to lease must be negotiated in good faith.
I think it's E.
Did I say another letter?
Yes,
E
you did.
is what I meant to say.
And just leave it in good faith.
And that's it.
Okay, Commissioner McGowan? Okay with that? Mr. Boygan?
I have a real concern with this. I just don't know where it's going. I don't know what that means. I think there's a real difference between discussing impacts on the surface and implementing the reasonable accommodation doctrine, which is a well-established principle under the law on use of the surface on the one hand, and on the other hand, engrafting onto what's the statutory requirement of reasonableness, some different standard of good faith that to me just injects uncertainty into the leasing process. Either the lease is reasonable or it's not. If we're going to have a role in determining reasonableness, okay, I can get behind that, and I think we should try to identify what we think is reasonable or not. But to add some kind of subjective factor to that mix is, to me, a recipe for just, again, creating confusion, bogging down the process, and so I don't favor it.
Okay, Commissioner Hawkins?
You know, it's hard to say, you know, did you stop beating your wife? I mean, that's the way I view the negotiating in good faith. But I do think maybe it is a little difficult for us to make a judgment on, you know, did they negotiate in good faith on this? I mean, there are extremes, but then you're in the gray area. I do have expectations that operators negotiate in good faith, so I'm not going to have heartburn over putting it in. I'm just
okay. Mr. Jolly?
Not real strong in favor of it.
All right.
Well, there's another one that's you know, pornography when you see it. You know, there's some of these that we hear about that obviously haven't been negotiated in good faith. But if you put it in here, does that mean it's not in everything else in our rules? I mean, that's what I kind of wonder about in putting in good faith here.
It's already in other parts of our rules.
Right. But I mean, you've got to put it in on each specific thing. I mean, I think it's kind of understood that everything in here should be in good faith. So I go either way with that one, but I don't think it's,
all right.
It might be helpful. The one thing that Commissioner Egger brought up that I think could be tweaked, or I would agree to, is finding reasonable effort into finding the right address. I think that is just an ongoing issue that could be tweaked.
And where would we add that? Because it's not it doesn't fit real well with a reasonable offer to lease, but it might fit with.
Yeah, if we put in E that they'll negotiate in good faith and they'll try to find reasonable addresses. Yeah, maybe where discusses notice.
All right, so let's set that aside for the moment, just to go ahead and see about where we think we need to add that, because I think we're coming up on a break and lunch, and maybe we can come back to that one. Plus, I believe it's 5:09. But what I'd like to do at this point, if commissioners, if it's okay with this, let's have again a vote on.
Chair,
Yes.
can I interject one thing that might end up being unhelpful?
Sorry?
Some of these concepts, I think, are things that we can explore more robustly in a statement of basis and purpose, such that things like terms of good faith and responsiveness are expectations of the commission.
I am completely comfortable with putting this in the statement of basis and purpose instead of in Rule 530E.
Very well.
Great idea.
Are we okay with that?
Sounds good.
Okay, so we'll leave the wording in the part C as is, and we'll add in the statement of basis and purpose, essentially said all offers lease must be negotiated in good faith.
Can I just add one more thing before we break? Which is that I do think and want to make sure that we don't lose that I felt it felt as though there was a consensus among the commissioners that there is a desire to, among perhaps other things in Rule 530, to have a deeper conversation about how we assess reasonableness. And so to add that to our to-do stack.
I have that noted.
Okay. At the risk of potentially prolonging this just a minute or two longer, can we do something with respect to the address issue in the statement of basis and purpose? Is that a spot? Yeah.
Reasonable diligence.
Yeah, reasonable diligence in obtaining current addresses.
We might have cured some of that by having these return envelopes go back to the operator already, hopefully.
Well, yeah, I think where I am on this is if a party doesn't get notice, they can't be pooled.
Exactly.
And so if it's not already clear in the rules, we need to make it clear that a party who has not received notice after an operator had, whether or not the operator has evidenced reasonable diligence or for whatever other reason hasn't been notified in accordance with our rules, that party is not bound by the order as far as I'm concerned. So I'm not sure we need to say that. If we do, I'm okay with saying it.
Essentially, they get what you're saying is that if they don't do their job and they can't find somebody, then the pooling order with this, essentially with the penalties and so on, don't hold, and those folks get a free ride.
You're getting a free ride. That's right.
Okay, which has happened.
You know, it's the operator's
I have no issue with that.
burden
Yep.
to
find
make
all the
sure if
owners
they
as
want to
best
pool
as they
somebody,
can.
they've got to get them notice.
Okay. So maybe we don't, if you're okay with that, then we don't need to go back and revisit the address issue because it's solved to some extent with the envelopes, return envelopes have to go back to the operator. And if they don't do their job, then those folks they don't notice are going to get a free ride anyway.
And if they haven't received
That's not
notice,
necessarily a free ride.
Chair?
Yeah, Director Murphy?
Yeah, I think pulling some of those concepts into why we're changing the return address language and noting that it's really incumbent on the applicant to find the last known address for these reasons.
Okay,
It's a direction I would like to take the statement of basis and purpose.
perfect. Does that work?
Sure.
All right. Very well. We have one item, we're a little bit behind. We have one item to come back to when we finish our lunch break, 5:09. Unless I'm not trying to drive this, if you want to address that before lunch or if we want to take the lunch break and then come back to that. What's your preference, commissioners?
Get her done.
I would like to have, a break though. We've been almost 2 hours here.
Mr. Chair,
Yes.
I apologize.
Sorry, you, but that's right. I forgot. Thank you, Director. Sorry.
Before we.
Mr.
break-
Davenport.
Thank you. Before we break for lunch or take a break at all, I want to go back and just clarify the record in regard to its comment 22. It's the determination of interest, that there's being no change to the rule or anything in regard to this issue. Is that what the commission decided? Okay,
Yes.
just clarifying for the
No
record.
change to the rule, but in the statement of basis and purpose, it'll be clarified or not?
But this is what I was curious about. I'm not sure it was clear at all exactly what. So we've already said no change to the rule at all, but there's something going into the statement of basis and purpose. This is what I don't know.
I don't think so. I think what we said was we were not going to change the rule. And
Right.
then staff acknowledged that if it felt like including this information in its pooling orders was something that it wanted to do, that it possessed the authority to do that today.
Yeah.
So they can look at that and evaluate whether that's valuable.
Okay.
That's comment 22 on page 37.
Right.
Yeah.
Thank you. That's all I needed.
All right. So Commissioner Hager, can we take a break? We don't have to take, just no lunch.
No. If we're gonna take a break, we might as well have lunch break.
Okay. Half hour?
Yeah.
We can go keep the lunch break short and then come back. All right.